Calling parties on Joseph Johnson and Brittany Chavis. Calling case number 21-58920, People versus Joseph Richard Johnson and Brittany Sada Chavis. Both defendants are charged with counts 1 and 2, assault with intent to murder, counts 3 and 4, assault with intent to do great bodily harm, less than murder by strangulation, counts 5, 6, 7, and 8, weapons, felony, firearm. Defendant number 1 is a habitual offender, second offense notice. Defendants are here today for a hearing.
Appearances, please.
Lori Morales Smith, P83353 for the people, Your Honor.
Hold on one moment, please.
Anything possible. As you said already, you keep your promise, Lord. I love you. I surrender to your will. I repent today. Go on.
Okay, good morning. Appearances, please.
Lori Morales Smith, P83353 for the people, Your Honor.
Good morning, and may it please the court. My name is Adam Clements, P number 77233, appearing on this matter on behalf of Mr. Joseph Johnson, who's also present by way of Zoom. Mr. Johnson, would you state your name for the record, please?
Joseph Johnson.
Counsel, second counsel, please.
Mr. Royal?
You have another one you can call?
Yeah, can you ask the county can get Rayshawn Gray?
Wait, I'm sorry.
Can you ask the county deputy can get Rayshawn Gray?
Rayshawn Gray, and in the meantime, just call another case. Okay. Rayshawn Gray, can we get Rayshawn Gray?
From the county.
From the county.
Calling parties on Nikita McKenzie. Calling case number 20-56917, People versus Nikita LaShawn McKenzie, aka Marquita Allen. Defendant is charged with count 1, weapons, firearm possession by felon. Count 2, weapons, ammunition possession by felon. Count 3, carrying a concealed weapon. Counts 4 and 5, weapons, felony, firearm. Defendant is a habitual offender. Fourth offense notice. Defendant is scheduled today for a probable cause conference.
Thank you. Before you put appearances on, let me welcome everyone, particularly those that are new to Zoom Gallery. If you are defense counsel, please let the prosecutor put their appearance on first. If we don't have a prosecutor, then we're going to pass on the matter. In like manner, if defense counsel, they don't step up and put their appearance on, we will pass on the case. It's nothing personal, but that's pretty much going to be the process. After defense counsel puts their appearance on, please don't start into the proceeding. I do need your client to put their name on the record, their own name on the record. If they're not here, please don't assume I know if they are or aren't there. Let me know. And if they're not there, let me know if you're requesting to waive their presence. That's going to be the launching pad for every matter that is called. If you are a defendant, please make sure that you keep your, everyone keeps their audio muted unless you're speaking. If you are the defendant, when you're speaking, you not only need your audio unmuted when you're speaking, but you also need to have your video rolling. So if you're not familiar enough with your device to understand how to utilize those tools, please make sure you take a moment and familiarize yourself with your respective devices. Please make sure that you are clothed, that you're wearing clothes. I emphasize that because of our past experiences. Please make sure that you're not sleeping on the video or doing anything that you wouldn't do inside of an actual courtroom. This is Zoom court, but it's tantamount to being in a courtroom. Please refrain from any profanity. And I think we should be able to get through this swiftly. Again, if your case is passed on because attorneys are not ready, it is not personal. We just need to keep moving to the next case. We will put you back in the queue and your case will be called. Appearances on this case that was just called. That's Mackenzie, please.
Bryn Bailey, Your Honor, on behalf of the people, P84009.
Good morning, Your Honor. Aaron Geyer, P39889. Your name?
Nikki McKinsey.
Thank you. Thank you, Ms. McKinsey. Okay, today is a PCC, I believe. Is that correct?
Yes, Your Honor.
Yes, Your Honor.
Pleasure.
Your Honor, the defense would request an in-person exam.
Okay. She had a capias that was issued in June. Has that capias been set aside? Has that been dealt with?
Yes, ma'am.
Okay. You already have discovery, I assume. Is that correct?
Yes, ma'am.
All right. We need an in-person examination date. This is a non-custodial matter. I emphasize that so that you are not shocked by the date for the in-person examination. I'm assuming you've had discussions with your clients, and all defense attorneys are having discussions with your respective clients on how the pandemic has affected the court system and the timing. So, Mr. Clerk, thank you.
December 20th at 11.
December 20th at 11?
1 second, please. No, ma'am. I'm unavailable for the week of September the 20th through the 27th.
December.
Oh, December. Yes, ma'am.
And
That's
what?
12/20 at 11 a.m.
Okay, December 20th at 11 a.m. And I'm going to make this one announcement as well. For anyone that has their case called after this one, I can certainly give out exam dates next week, next month, September, October. I can give those dates out, but if you have a non-custodial matter and it's not a capital offense, there is a high likelihood that you will be waiting on whatever soon date you get. You will be waiting in the hallway until 12:30, which is we're mandated to do a hard stop. And you will likely have to get a new court date. But as defense counsel, as you know, it is a roll of the dice, because on whatever date, if you had next week, all the witnesses may not show on all the exams, and we may have a wide open space, or there may be a ton of waivers. So it really is a roll of the dice, but the consequence of all the exams actually going, which we're busting at the seams with exams every single day, the consequence is that you could potentially, very likely, have your matter called in at 12:25 to get a new date. So for anyone that's listening, if you want a date and you're not, if it's not a custodial matter and you want a date right around the corner and you're willing to take that risk, I'm open for it. But our calendar is naturally falling right now in December. And I know that's quite shocking, but again, for those of you that work in the court system on the daily, you understand why this is happening. So if you want to hasten that date, just let me know. But please do not get upset if on that date, you're called in at 12:30 after you've sat there for hours just to get a new date. I can't guarantee anything in that regard. So if December 20th works for you, that will be at 11 a.m. And Ms. McKinsey, you must be present in the courtroom, not on Zoom. I emphasize that because oftentimes people are confused on the date and they appear on Zoom when they actually should be here. You must be present. Presumably, we'll still have some level of screening that is required to enter the courthouse. So please make sure that you arrive with enough time to pass through that screening in order to be present in the hallway when your case is being called into the courtroom.
Okay.
Is there any? You're welcome. Is there anything else you'd like to address, defense counsel?
No, ma'am, thank you.
Madam Prosecutor.
No, Your Honor,
Thank you. Thank you. All set. Bond will continue.
Calling parties on Victor Rodriguez. Calling case number 2158045, People versus Victor Enrique Rodriguez. Defendant is charged with count 1, armed robbery. Count 2, weapons, firearms. Counts 4 and 5, weapons, felony, firearm. Defendant is scheduled today for a probable cause conference.
Thank you. We can recall Clements and Royal after this one.
Yes, ma'am.
Appearances, please.
Good morning, Your Honor. Brenda Bailey on behalf of the people, P84009.
And good morning, Your Honor. Hassan Bezi, P78448 on behalf of Mr. Rodriguez. Victor, state your name for the record, please.
Victor Rodriguez.
Your Honor, if you even recall.
I'm sorry, say again?
I'm sorry. Your Honor, if you may recall, we adjourned this a couple weeks ago to see if I am going to stay on board on this case. Originally, me and another attorney filed an appearance. I'm not sure whose appearances you have in that file, but at this time, regardless, I'm asking to withdraw from this case. Mr. Rodriguez is going to seek another counsel. I did have a chance to talk to him. I don't think he's got any objections to it. And I heard your speech with regards to the dates that you're given. So instead of adjourning it out another 2 or 3 weeks for PCC, maybe we can set it for exam in December. That'll be plenty of time for another attorney to come on board. I will share discovery with him if it's up, but it's up to the court.
Mr. Bazzi, first of all, good morning to you, sir.
Good morning.
And second, and per my notes, we set a new PCC, but you also locked in an exam date in August.
Yes, Your Honor, but at this, yes.
And so if a new attorney is coming in, I certainly am not going to, I don't know how much time a new attorney would need to review matters, but I wouldn't force them to proceed in a matter before they're ready. Do you know who you're going to hire, or are you seeking a court-appointed counsel, Mr. Rodriguez?
No, Your Honor. He did retain me and another attorney, but there's another attorney that we have been in talks with. I did share. He is going to meet with them hopefully today or tomorrow. At this time, I'm not sure if he's going to be formally on board, but I think he is, Mr. Wright Blake.
Okay. I see that the co-defendant has the August 2nd date as well for an examination.
Yeah, that's why we set it for an examination on that date at this time.
What I'm going to do, see, this is my concern, Mr. Rodriguez. You're looking at some real serious allegations, and what I don't want to do is be stagnant while you're trying to figure out. You really should have come today with a plan of action, and I'm a little bit concerned when you're facing a life offense here that you're saying you're not really sure who's going to represent you. There's nothing definitive on the record. I'm going to adjourn this for 1 week for another PCC so that whomever it is going to be representing you is present. They need to be present in Zoom Gallery next Thursday. That's going to be the 29th of July. If you do not have an attorney that you retain by that time, then you need to let me know what you're asking the court to do. If it's a court-appointed counsel that you're going to need at that time, then so be it. But this is a situation that I do not want to just sit here in this zone of non-action. Mr. Rodriguez, do you understand?
Yes, I understand.
Okay, so July 29th is the new PCC. I'm tentatively going to hold that August 2nd date because of the co-defendant's exam date. And if counsel, if it's Mr. Blake, I would imagine if he's able to receive the discovery, he may be able to proceed on that date if he's available, and we'll cross that bridge when we get there. July 29th at 8:30 via Zoom is the next PCC.
Thank you, Your Honor. That's fair enough. I am gonna have a conversation with Mr. Blake today and his other attorney and Mr. Rodriguez. So hopefully he'll have something by next week.
Okay, and so Mr. Bazzi, you are going to be withdrawn from this case. In the event that you do speak with Mr. Blake today, if you have discovery, if you could forward that on to Mr. Blake, that would be helpful as well.
I definitely will. And I gave Mr. Rodriguez discovery also. So, Your Honor, is my representation withdrawn at this time? Is my motion granted?
Yes, sir. Motion is granted and you are withdrawn from this case.
Thank you very much, Your Honor. It was great seeing you, and have a good day to you and your staff.
You too, likewise. You're all set, Mr. Rodriguez.
Recalling parties on Joseph Johnson and Brittany Chavis. Recalling case number 2158920. People versus Joseph Richard Johnson and Brittany Sada Chavis. Both defendants are charged with counts 1 and 2, assault with intent to murder. Counts 3 and 4, assault with intent to do great bodily harm, less than murder by strangulation. Counts 5, 6, 7, and 8, weapons, felony, firearm. Both defendants are scheduled today for a hearing.
Thank you. Appearances, please.
Lori Morales Smith for the people, Your Honor, P8333.
You're on mute, Mr. Royal. John, you got to unmute.
Good morning, Your Honor. May it please the court, John Royal, bar number P27800, appearing on behalf of defendant number 2, Brittany Chavoy, who is present on the Zoom.
May it please the court.
Oh, I'm sorry, Ms. Chavoy, could you please state your name if you're here?
Brittany Chavoy is here, Your Honor.
Thank you.
May it please the court, Your Honor. Good morning. My name is Adam Clements, P number 77233, appearing on behalf of Mr. Johnson. Would you state your name again for the record, please?
Joseph Johnson.
Okay, thank you. So I asked Mr. Clerk to gather you up so that we could address, what was the issue? We had the bump. Both of your clients are not in custody, correct?
That's correct, Your Honor.
That's correct.
And it's scheduled for an examination, a second date of examination, if in the event that we would need it on August 26th. I'm just kind of going off memory, Mr. Clerk.
Yes,
and
ma'am.
we put an in custody matter on that date. Is that correct?
Correct.
Okay, so obviously, as you know, in custody matters take priority over non-custodial matters. I'm hoping that our August 24th date, which we're still going to keep, is going to afford us an opportunity to complete the exam. If not, we do need to solidify another second date. I'm not sure if all of that's making sense, but that second date of August 26th had to be filled with an in-custody matter that has to be heard within a certain span of time. So if you could look at your calendars and let's set a tentative second date in the event that is needed. Mr. Clerk, what date can we give? At 1:30? Whatever is available. This is not custodial, so I can't bump other matters out. I just want to have something on the books in the event that we need a second date.
September 3rd is open.
September 3rd at 1:30.
I'm available.
That's fine.
That is okay for the people as well.
Okay, so just to be clear, the August 24th date is still a go. August 24th at 1:30, right?
Yes, ma'am.
Okay. We are only setting a new second date in the event that it's needed. So August 24th and September 3rd, both at 1:30. Please disregard the August 26th date that we had. Does anyone have questions about that or?
Understood, Your Honor.
Thank you, Your Honor.
Thank you.
Good morning, Judge. I'm back on Gray, ma'am. Richard Glenda.
Okay. Calling parties on Rayshawn Gray. Calling case number 21-59462. People versus Rayshawn Man Gray, aka Rayshawn Darnell Gray, aka John B. Ray, aka John Doe, aka Tori Terrell. Defendant is charged with count 1, assault with a dangerous weapon, felonious assault. Count 2, malicious destruction of personal property less than $200. Defendant is a habitual offender. 4th offense notice. Defendant is scheduled today for a probable cause conference.
Thank you. Appearances, please.
Good morning, Your Honor. Bryn Bailey on behalf of the people, P84009.
Good morning, Judge. Richard Glenda for Mr. Gray, 32990. Ma'am, this is the initial PCC. I believe Mr. Gray is in custody. I just found that out. I had no contact information, having just received this assignment late last week.
Okay, I'm sorry. You said you need another PCC, Mr. Glenda?
Yes, in the discovery, yes.
Is your client present?
I believe he's in custody.
Yes.
Please state your name.
Rayshawn Gray.
Thank you. Okay, so you want a week adjournment?
Judge, if we could have, yeah, we could have 1 week for an adjourned PCC, Judge.
Okay, so that would be July 29th. I do find
Yes.
the PCC so that you can receive and review discovery. The new PCC is going to be again July 29th at 8:30 via Zoom.
All right, thank you. And I'll see you, Mr. Gray, in the county.
Thank you.
Sorry.
That's okay.
That was the county jail. Can we get William Franklin from the county jail?
I'm ready on William Franklin. We haven't done them yet.
Okay.
Thank you.
Calling case number. Calling case number 1959801. People versus William Franklin. Defendant is charged with count 1. Home invasion, 3rd degree. Count 2, malicious destruction of personal property, less than $200. Defendant is a habitual offender. 2nd offense notice. Also calling case number 20-58181. People versus William Norman Franklin. Defendant is charged with 1 count, home invasion, 1st degree. Defendant is scheduled today for probable cause conferences on both matters.
Thank you. Appearances, please.
Morning, Your Honor. Jacob Bloomers, P77307 on behalf of the people.
Good morning. NDS Detroit by James Parker on behalf of Mr. William Franklin, P53832.
Good morning to you, Mr. Parker. And your client?
Franklin.
William Franklin.
Thank you. Okay, today is a PCC. Counsel, what is your pleasure on these 2 files?
Well, Your Honor, first of all, I believe Mr. Franklin does have another case. So I think maybe we need to address that one as we address the other 2.
Oh, I'm sorry. I was talking to the clerk. You said he has a 3rd file?
Yes.
Oh, I don't know what that is.
Is that a new file, Mr. Parker?
No.
So I've just got the 2.
And there should be the same complaining witness on 2 cases.
Yeah, I have. So the 2 I have, the 2019 case, Deidre Thompson is the complaining witness, and then I have the 2021 case ending 5778. Deidre Thompson is also a complaining witness on that one, on the misdemeanor.
You case in front of Judge Garrett. There's a third one.
I missed that. What, Judge?
That doesn't correspond with the numbers I have. You said you have, Mr. Bloomers, what did you just say? The case ending in 5, you had a 7 in there, didn't you?
Yeah, I could be misreading it. I'm sorry. I'm trying to use the 36 website's not working for me. I see 210557778.
I don't know what that is. I've got 200588181 and 19059801.
What were the counts on the 2021 case?
Well, I don't have a 2021 case. That looks like your clerk just handed me a DB in front of Judge Garrett.
Okay, I'm sorry. Again, I am trying to look up ROAs here, but the 36 website is not working.
So there's a misdemeanor DV, which is 210444904. And Mr. Clerk just told me that's in front of Judge Garrett.
Yes. Okay. So here is the situation, Judge. There are 2 felony cases. Just a little background. They were both set for exam back on April 13th. The situation right now is that Mr. Franklin, and it's on my docket sheet, Mr. Franklin. Oh no, see, that's the other case. Mr. Franklin was not arraigned, I think, on the bench warrant in this 2021 case. I know it was set for exam because I'm looking at the ROA in the 2021 case, and it was set for exam on 4/13 right along with the 2019 case. But it looks like he hasn't been arraigned on it because he was capious on these cases back in April.
Okay, still I'm a little confused because what Mr. Clerk handed me is a 2021 case, which appears to be a misdemeanor domestic violence. But I do have 2 felonies, a 2019 case and a 2020 case. Looks like he was capious on April 13th for the an exam on the 2019 case. I don't have any information on the 2020 case.
I'm showing that on the 2020 case, he failed to appear in front of Judge King. And I'm not, and then that case that was in front of Judge King was transferred to us last week.
Okay, so
That's correct. There is a case that Mr. Franklin had in front of Judge King, and then Judge King saw that you had a couple of cases, and I think he moved his case to you.
Okay.
If that's the right case, I don't know. I don't have all the case numbers.
No, you're right, Mr. Parker, and I do have the older case, so it makes sense that it came to me, the 2020 case. So what would you like to do here?
Well, I would certainly like to set a preliminary examination, and what I'll do is if I find another case, then I will let the court know, and we could just set it for the same date that we're doing the 2 cases that you have before you right now.
Okay, so I do have that 2021 ROA right here, but it looks like a misdemeanor.
Do you have a date of when that event occurred? I do not know about that particular incident. Is that something that happened? Go ahead.
July 10th, 2021.
See, that's too new.
I have the February felony case that's from 2021. That's the MDOP, fire, police property, and domestic violence. And that he was capious on in this court back in April 13th.
Your client has a lot going on.
I do have, let's see. Can I have, can we recall this in about 10 minutes? Let me go through my file, and I thought the court had all of these cases in front of them. Let me get the dates and that type of thing, and then we can talk about it correctly. Because I do want to set all three cases for one day for prelims, please.
Mr. Clerk, is this a mis- or Judge Garrett?
Is that a misdemeanor?
Are you, is there a third felony in the system? I think this could really, I think, be easily figured out. Is this, I thought you handed this to me and said this was a misdemeanor before Judge Garrett, the July 10th.
It is a misdemeanor, right?
Okay, is there a third felony case?
I'm not seeing one, Your Honor.
No,
Yes, I have the file in front of me.
Wait, there's one from 2019.
Yes.
Okay.
There's one from 2020.
Yes.
There's a misdemeanor case from 2021 that happened last week.
And then there's a felony case from February 2021.
Okay.
What's the number on that?
That I don't.
All right. Well, I'm going to I have the number handwritten on my file, and so I'm going to double check right now that that is correct.
What's the number?
It is 21055-778.
Okay, we're gonna recall this.
I'll have the dates in a minute, Your Honor. Why don't you recall it? I'm not going anywhere.
Mr. Clerk said his name was spelled wrong on that last number you just gave me, Mr. Bloomers.
I see that.
Okay.
All right, we're gonna recall this in just a moment.
No problem.
They spelled his first name wrong.
Thank you.
The Wayne County Jail, can we get Mr. Thomas, Von Shea Thomas? Thank you. Calling case number 1-855-5769, People versus Von Shea Thomas. Defendant is charged with count 1, larceny in the building. Count 2, embezzlement, agent or trustee, $200 or more but less than $1,000. Also calling case number 2056038, People versus Von Shea Thomas. Defendant is charged with count 1, malicious destruction of personal property, $1,000 or more but less than $20,000. Count 2, disturbing the peace. Defendant is scheduled today for a tether violation.
Appearances, please.
Good morning, Your Honor. Bryn Bailey on behalf of the people, P84009.
I'll say Thomas.
Okay, I'll call something else. Calling parties on Carter to Shea. Calling case number 2159434, People versus Carter to Shea. Defendant is charged with count 1, armed robbery. Defendant is scheduled today for a probable cause.
Thank you. Appearances, starting with the prosecution first, please.
Good morning, Your Honor. Bryn Bailey on behalf of the people, P84009.
Good morning, Your Honor. Patrick Nineheis, P76343 on behalf of, well, it's Carter Takashi, but I think it's in the computer system wrong. It might be Takashi Carter.
And your client, can they state their name?
It's Tashay Carter.
Thank you. What's your pleasure, counsel?
Judge, at this time, Miss Bailey did send me all the discovery on the 19th, which I'm very appreciative of. I've been trying to open it the last day or so, and I've had some issues, but if I keep having issues, I'll get a hold of Miss Bailey. But we want to set it for a preliminary examination, and then I would ask that you set me in a breakout room with Miss Carter.
Okay, thank you. Can we have an in-person examination, please?
Judge, I thought she was out of custody.
I'm sorry?
I do see Ms. Carter out of custody. I will file a first amended to correct her name. I do have it listed as Carter.
What's the relevance? I'm sorry, why did you say you think she's out of custody?
Judge, you said an in-custody date. So I was trying to make sure.
I said a date yet?
You said in person.
In person.
But I knew what you meant.
Oh, in person.
Yeah, he's saying that she's not in person.
Can we have an in-person, and make whatever are
Yes,
necessary with the name? Can you set an in-person examination date?
December 20th at 11:30.
December 20th at 11:30?
Judge, I'm out of town that day. The week before?
Can you just pick another
No,
date?
actually, no, I can do December 20th, Judge. Thank you very much. I apologize.
December at 11:30.
11:30 a.m. Thank you.
Thank you, Your Honor.
Thank you.
And then, like I asked, can I please have a breakout room, Ms. Carter, if possible?
Where is Ms. Carter?
She's on 211-71708's iPhone.
I'm not familiar with how to work this.
Well, Ms. Carter, you could just give me a call if you can write down my number really quick.
Okay, 1 second.
Very.
Okay, Ms. Carter, it's 313-244-3500. And call me right now, okay?
3500?
Correct.
Okay, thank you.
Yep, bye. Thank you, Judge.
You're welcome.
Good. And who is this? Yeah, who is this?
Okay, let's call this case. Got nothing else. What's the name on the case? Jackson. People versus Jackson. This is what? I don't have the case.
Right.
Okay, she's been around. She hasn't been going
Calling
anywhere.
case number 1860446, People versus Jantina Lavette Jackson. Defendant is charged with count 1, operating while license suspended, revoked or denied, causing death. Count 2, operating while intoxicated, causing death. Count 3, child abuse, 2nd degree. Defendant is scheduled today for an examination.
Thank you. Appearances, please.
Good morning, Your Honor. Abigail McIntyre, appearing on behalf of the people, P7 and 1143.
And good morning, Your Honor. May it please the court, Kim Michon, Neighborhood Defender Services, P59167, on behalf of Ms. Jackson, who is live in courtroom. We would move to sequester if there's more than one witness, Judge.
Okay, can you please state your name?
Jantina Jackson.
Okay, how do you, tell me your name again?
Jantina.
Oh, Jantina. Okay, thank you. Sequestration will be granted. Do you have an officer in charge present?
I do have an officer in charge and one witness.
Would you seek to have your officer in charge remain?
Yes, please.
Any objection?
No, Your Honor, unless they're testifying.
I don't believe he's going to be testifying.
Okay, then.
But I can sequester both of them. I have no problem with that. Although he is listed as a complainant, Your Honor, so he's entitled to stay in court.
The officer in charge?
Yes.
Okay, and could you please tell me his name so we can have
His
it on
name
record?
is Trooper Michael Sherry. He is the one in plainclothes.
Okay, thank you. He will be permitted to remain in the courtroom. If there is anyone else inside of the courtroom connected to this case, please exit the courtroom. The pandemic restrictions are still in place, so the courtroom is, I believe, free of spectators. There are a few people that are in here affiliated with the prosecutor's office, but the rest are working the courtroom or connected to this case. The Zoom gallery, I am going to restrict the Zoom gallery. If you hear attorneys or if you hear anyone chime in, it's because I've let them in and they are an attorney. Otherwise, the Zoom gallery is going to be restricted. The third tier to sequestration is that this is live streaming on YouTube. So if there's anyone watching the live stream that should not be watching because you're either a witness or a potential witness, now would be the time to stop from watching the live proceeding, as it may preclude you from testifying in the future. With that being said, are there any other preliminary matters?
Your Honor, I have been in contact with Ms. Michon, and we do have several stipulations as to records that will be stipulated and admitted.
Okay.
The first is the medical records from the defendant. Well, let me start with exhibit 1 that I have in mind. Is the driving record from the Michigan State Police for Ms. Giantina Jackson that indicates her license was suspended as of 9/21/2016 through 5/21/2018. The document is approximately 8 pages in length. It has been presented to Ms. Michon and reviewed as part of just the initial discovery. Exhibit number 2 is the labs from the Michigan State Police, laboratory numbers TX1758802. Record number 1 indicates that there was no alcohol, that is 0 grams per alcohol per 100 milliliters of blood. Record number 2 indicates that THC 7 nanograms per milliliter was detected. And both of those are dated May 9th, 2017. Exhibit number 3 is the record from the Wayne County Medical Examiner's Office. It is ME case number 175616, which is authored by Jeffrey Hudson, MD. And the postmortem examination of the body was performed on Jaslyn, which is JASLYENN Marie Summer Patterson, on May 7th, 2017. And the summary and opinion states that it is my opinion the death was caused by blunt head trauma. According to the investigator's report, the decedent was a backseat passenger of a motor vehicle involved in a rollover accident. Complete autopsy revealed blunt head trauma. And then the final line says manner of death is classified as an accident. And exhibit number 4 is the medical records of Giantina Jackson from May 6th of 2017, which indicate that she again was positive for cannabinoids, which was 50 nanograms per milliliter.
Ms. Michon, I'm assuming you, I think it's already been stated, have had an opportunity to review what has just been articulated on the record. Is that true?
That is true.
Is there any objection to the admission?
No, Your Honor.
Proposed exhibits 1, 2, 3, and 4 will be admitted as such. Have they already been marked?
They have been.
Okay.
And I will present them to the court reporter.
Okay, you can do that now.
Unless the court would like them.
No, you can, she has the stickers and she can do that now. And while you're doing that, Madam Court Reporter, I'm gonna go off the record and speak to some of the attorneys. Mr. Johnson, what are you here for? And good morning.
Judge, good morning. I have a PCC on a homicide for Mr. Simone.
Okay, Ms. Colthurst, I think we called your case. We'll recall it before we begin this exam.
Thank you, Your Honor.
Mr. Parker, are you ready to recall your matter?
Yes, I am, Your Honor. I believe I have the information that the court needs.
Okay, and who's the prosecutor I see? I don't recognize you, sir.
All right.
Elsie?
Yes, good morning, Your Honor. I'm the prosecutor on Simone Jones, Mr. Johnson's case.
Okay, do we have those individuals? Division 2, what's your name? Division 2, what's your name, sir?
Simone Jones.
Okay. Please.
Okay. Are we ready? So I think you record back. Recorder calling.
Calling parties on Simone Jones. Calling case 1-59370. People versus Simone Brandon Jones, aka. Calling parties on Simone Jones, Calling case number 21-59370, People versus Simone Brandon Jones, AKA Samaj Johnson, AKA Davion Brandon Jones. Defendant is charged with count 1, homicide, murder, second degree. Count 2, assault with intent to murder. Count 3, weapons, firearms, possession by felon. Counts 4, 5, and 6, weapons, felony, firearms. Defendant is a habitual offender. Fourth offense notice. Defendant is scheduled today for a probable cause count.
Okay, thank you. Appearances, please.
Good morning, Your Honor. Ryan Elsey appearing for the people. My P number is 81329.
Good morning, Your Honor. May it please the court. Bertram Johnson appearing on behalf of Simone Brandon Jones, P46646.
Good morning. And Mr. Jones, could you please state your name, sir?
Simone Jones.
Thank you. Mr. Johnson, what's your pleasure here today?
Judge, this is our first PCC. We have received discovery. I've been in communication with the prosecutor. I'm sure if there's any other outstanding discovery, we will secure it. We're asking for a preliminary exam, Judge, though I know it's going to take some time for us to get through this discovery, as well as for me to meet with my client.
Is there a particular time frame you're seeking? Because of course, with your client being in custody, I've got to make a way, but I don't want to bring it closer than you are going to be ready.
Judge, that's why I'm asking, what kind of dates are you kind of dealing with? Are we 30 days out or more?
No, for in custody, I'll give you what you want. If you want it tomorrow, I'll give it to you. But, those dates are not, we don't have anything available, really. We have nothing available. But I'm going to make a way because your client's in custody. So I don't want to, if you're not going to be ready to go.
Judge, I would say sometime in September.
Okay, first week in September. What's our first afternoon?
In September?
Yeah, we get a 1:30 for homicide.
Yes, ma'am.
How many potential witnesses, prosecutor?
Your Honor, at this point, I anticipate only needing 2 witnesses at the exam.
Okay, what's our first available afternoon in September? Don't we have the 3rd, maybe?
The 3rd was available.
Is it, or did we just put something there?
We just gave the 3rd to the 2 defendants.
Okay. The 8th.
I have the 9th.
The 9th?
September 9th.
September 9th at 1:30?
That works fine.
Okay, the in-person examination, September 9th at 1:30. Was there anything else that you wanted to address?
Not at this time, Judge.
Your Honor, there were a couple of issues I was hoping to address. Number one, Mr. Johnson and I have stipulated to a proposed protective order governing the discovery that's been provided. I did try to email that order to the court earlier this week for review, but I'm just wondering if I may have not sent it to the right person. I tried sending it to Tammy.
Yeah, Tammy's on holiday. Mr. Sanders, can you give him your address real quick?
I'll put it in the chat.
It'll be in the chat. If you would look in the chat, Mr. Clerk is going to put his email there. If you could send it directly there, he can pull it off and I'll sign it today.
Okay, thank you, Your Honor. I will. I'll do that promptly. And there's one other issue, and I have a request of the court, and it's a somewhat unique request and one that I don't take lightly. But I am asking for the court to revoke Mr. Jones's jail call privileges. And the reason is that since he's been in custody, I have requested the calls that he's placed from his account in the Wayne County Jail. And I have identified a couple of calls in which he has rather expressly attempted to tamper with the surviving eyewitness in this case, who is the named complainant on the AWIM charge, by having an intermediary reach out to the witness to pressure him. And I have those calls available. I can place those on the record. I can place a summary on the record, whatever the court prefers. But because this is a case where that witness's safety is crucial and his appearance at the exam is going to be crucial for the case to be able to move forward. I want to make sure this is shut down.
Okay, so two things. Number one, have you, and I'm assuming you have shared this concern with Mr. Johnson?
I have, Your Honor.
Yes,
have you forwarded that information or a summary of the a copy of email recording of the calls that you're concerned about to Mr. Johnson?
I have, Your Honor. I did not receive and review the calls until yesterday, but I did send Mr. Johnson 2 specific calls that raised these concerns, along with a brief summary.
Okay, so yeah, go ahead, counsel.
No, go ahead, John. I'm listening.
I was going to say revoking someone's phone privileges is kind of a big deal, but I'm prepared to do it if there is a basis. I haven't heard the calls. I'm certainly, as an officer of the court, I would imagine you are representing what you believe is an accurate concern. Mr. Johnson, what's your take on this? What's your posture?
Judge, I've had the opportunity to listen to the jail calls. I haven't, I don't have a summary of word for word unless I missed that somewhere, but I did review, me and my paralegal. I would indicate to the court this. I visited my client on my initial interview. And of course, one of the things I did was I clearly admonished him on jail calls. I talked to him about the gravity of jail calls, what he could say and what he couldn't say and all that, Judge. He was very admonished. And I told him specifically, I said, if you haven't already harmed yourself on the phone, do not use the phone. Now, I reviewed those calls, Judge, and one thing I would say, there was some comments about the witness, but that conversation was related to knowledge of him. These parties knew each other. There was some conversation about that. But what there wasn't on the record was any attempt to there was some conversation about reaching out to the other side and asking them to quit putting his name in this, because my client felt as though the parties knew each other and he didn't want his name to keep coming up because he felt that's why he's here. But there was nothing malicious about it. I did see some cautionary comments about he didn't want to cause any problems or something of that sort, but nothing about harming the witness, nothing about paying off the witness, nothing about doing things that we see a lot. So I believe, Judge, a strong admonishment at this time. And of course, the prosecutor will continue to monitor his calls. I would ask us to give another short window. If there's something that comes up that's remarkable, I would agree that we come in and address it and let the court revoke it. And I understand, but I will not tolerate, and I will visit my client today or tomorrow. There was a surge, so we haven't been able to get in. I'm sure that's over, but I will meet with him again and admonish him.
Okay, Mr. Prosecutor, is there any way, I mean, I guess you could give a summary, but we are getting ready to start an examination here, and we've got probably 5 behind it that we need to finish before 12:30 somehow. I'm just wondering if you could maybe forward, are these lengthy calls?
No, Your Honor, they're not lengthy calls, and I have them ready that I could play for the court right now. If the court wanted to take about 10 minutes or so to listen to those. But I can also, I have a more fulsome summary that I prepared after I sent the calls to Mr. Johnson last night that I could make a record of if that would be something the court wanted to.
And could you send me that?
Are you available at 1:30?
Your Honor, I'm unfortunately not. I have a bond hearing at 1 and then an in-person sentencing at 2 o'clock. That's likely going to take a good portion of the afternoon.
Okay. Yes. Can you push play now, maybe?
Yes, sure. And would it be possible to, I don't know if the share screen function is.
Did you have a summary that you could send me right quick?
Yes,
or
sir.
was that just the email?
No, I'll send you the more detailed summary right now, Mr. Johnson.
Thank you.
Your Honor, this is Schloff. Is it possible to do Mr. Choates, because we're going to lose our prosecutor if we don't get to it?
Sure. Calling people versus Choates.
No, Choates will be right after Mr. Jones. They're in the same place.
Okay. Well, then we need to finish this real quick.
Okay, sorry.
Unless you're going to waive his presence.
For an exam date, yes.
Choates is present at the jail.
I understand, but we're not quite done with Mr. Jones. So unless you can swap him out, like if he's right in that room with you.
Yes, Judge. Stand up. You sit down.
5954.
One through 7, criminal sexual conduct, first degree. Defendant is a habitual offender. Fourth offense notice. Defendant is scheduled today for a probable cause conference.
Thank you. Appearances, please.
Good morning, Your Honor. Brittany Johnson on behalf of the people, P83513.
And good morning, Your Honor. For the record, James Schloff on behalf of Mr. Choates, he's present today via Zoom. My bar number is 30720, and we consent for this hearing to be held by Zoom.
Thank you. Mr. Choates, please state your name. You have to unmute, sir. Mr. Choates, could you please ask the deputy to unmute you?
Here we go.
Please state your name.
He's still muted.
Okay, the record should reflect that I see Mr. Choates. He's physically on the image, the video image there, but we cannot hear him state his name. He's raising his hand. Mr. Schloff, what's your pleasure?
Your Honor, we need to ask for an in-person preliminary exam, please.
Okay, this is a custodial matter. What's our first available in-person exam date?
1:30.
How many potential witnesses do you anticipate?
2 for the people, Your Honor.
Yes.
Okay.
I'm sorry, did you give a date?
No, he's looking for it. September 10th, 1:30.
September 15th.
September 15th at 1:30.
Good for the people.
It's going to be holiday that evening, and I'm going to have to do some things to prepare. It's Yom Kippur that evening.
Yes, no worries. I'm sorry. So September 17th, is that available?
I got an appointment that afternoon.
September 20th at 1:30.
20th is fine.
No.
September 21st.
21st is good. No?
22nd.
September 22nd at 1:30.
Good for the people.
That'll be good. I've got a 2:30 there someplace, so I don't think it'll take that long.
Okay, thank you so much. We'll see you then. If there's any issues that arise between now and then, please alert the court and the prosecution, and we'll tee it up for whatever you.
Will the court order a pretrial services report for
Sure.
bond consideration? And When it comes in, we'll discuss the case.
I surely can. I'm making that referral right now, that notation. In the event that you receive that before the date and you wish to address bond, please notify the court and the prosecution, and we'll tee it up for a bond motion.
Thank you. Mr. Choate, I'll be glad to see you sometime. Thank you.
Could I talk to the deputy to swap Mr. Choate for Mr. Jones?
Your Honor, this is Attorney Susanna Kostowski. I have a preliminary exam scheduled for this morning. We are waiving the exam. I sent in the waiver to your clerk.
Is Harris present?
He's on somewhere. He's in the waiting room, he said.
Yes, ma'am. Calling case number 20-61614, People versus Deontay Juan Harris. With count 1, controlled substance, delivery or manufacture, cocaine, heroin, or another narcotic less than 50 grams. Count 2, controlled substance, manufacture, marijuana, methamphetamines, ecstasy, and cocaine. Count 3, stolen property, receiving and concealing a motor vehicle. Count 4, controlled substance, possession of cocaine, heroin, or another narcotic less than 25 grams. Defendant is scheduled today for an examination.
Thank you. Appearances, please. Prosecution, Ms. Bailey, is this general warrants? Is it a drug case? Harris?
Harris, I have his, Mr. Slusky's case, Your Honor. I'm gonna go grab him.
I will hear.
Is Wanda Cal here? Is Wanda Cal here?
I haven't seen her yet.
Mr. Jones is back. Mr. Prosecutor, is it Mr. Elsey, I think? Are you ready to recall that matter, or you need some more time?
Yes, Your Honor. If Mr. Johnson's ready, I am.
Yes, Your Honor. And I would, Judge.
Hold one moment.
Yeah.
Hold one moment. I'm so sorry. Mr. Slusky has returned. This is People versus Deontay Harris. Appearances, please.
Good morning, Your Honor. Jacob Slusky on behalf of the people, P83677.
Good morning, Your Honor. Susanna Kostowski, P39535, appearing on behalf of Mr. Harris, who is with us via Zoom.
Please state your name.
Deontay Harris.
Thank you. Today is the date and time set for an examination. Madam Defense, what's your pleasure?
Your Honor, my client is waiving the exam. I submitted to the court a signed waiver that I signed, and I also signed Mr. Harris's name to the waiver with his consent. Is that right, Mr. Harris?
Yes.
Any objection to the proposed waiver?
No, Your Honor.
Mr. Harris, do you understand the allegations against you, sir?
Yes.
You understand that you have a right to a preliminary examination?
Yes.
You understand that if an examination did occur, that the prosecutor would need to establish by a probable cause standard only that crimes were committed in the city of Detroit, County of Wayne, and that you probably committed those crimes?
Yes.
And if the prosecution was able to meet that burden, the matter would then be bound over to the circuit court for further proceedings. Do you understand that process, sir?
Yes, Your Honor.
The representation that's been made here today is that you wish to waive, to give up your right to preliminary examination. Is that true?
Yes.
Do you understand that that means that this matter would automatically be bound over to the circuit court for further proceedings without the benefit of an examination at this phase?
Yes.
Is that what you still wish to do?
Yes, Your Honor.
Are you sure? All right. That is the $1 million question here, sir. I need an audible answer.
Yes.
Do you want a moment to speak with your attorney on breakout room?
Yes, can you give me a minute to speak with her?
Yep. Mr. Clark, were you trying to get my attention?
No, I was just trying to give you the
Oh, on which case? Yes. Oh, okay. are we? How many potential witnesses do you have, Ms. McIntyre?
One, maybe two.
Recalling People versus Jones, 210-59370. Appearances again, please.
Good morning again, Your Honor. Ryan Elsey appearing for the people.
Bertram Johnson appearing on behalf of Mr. Jones.
Jones, take your name, sir.
Simone Jones.
Thank you. Mr. Prosecutor?
Yes, Your Honor. I do have the calls available to play for the court if that's what the court wishes for at this time.
Yes,
if I may, Judge, I was just going to say, Judge, I don't know if you were sent the summary of the jail calls, but I would even stipulate to you reading over it right quick, just one page, and then we could, if the court wants to do that, because the summary kind of, I would stipulate to the accuracy of the summary.
Tell me what you want to do. Tell me what you want to do, Mr. Prosecutor. It's your motion.
Well, Your Honor, I'm happy to send the summary to the court. So if you want to take a look and see if that is sufficient for you to make your decision, I'm fine with that. I can send that over right now.
Oh, I thought he sent it.
Yeah, and
whatever works.
Yeah, I just sent that to Mr. Johnson. So if I can forward that along to Mr. Sanders right now. I'm copying and pasting, and it should be in his inbox momentarily.
And so then what I'd like to do is, could I trouble you to zoom back in around 12?
That works for me, Your Honor.
Thank you so much. Mr. Johnson. Oh, Deputy, can we have Jones as well? Is it possible, Deputy, to have Jones at 12?
Yes, we'll make it work for you, Judge.
Thank you so much. Thank you so much. Okay, we're back on the record in the matter of People versus Jantina Jackson. This is 180604446. Appearances, please.
Good morning again, Your Honor. Abigail McIntyre on behalf of the people.
And
P71143.
Sorry. And good morning again, Your Honor. Kim Deshawn, Neighborhood Defender Services, P59167 on behalf of Ms. Jackson.
Thank you. And your name again?
Jantina Jackson.
Thank you. All right. We put some stipulations and exhibits that were admitted 1 through 4. Sequestration was ordered. Is there anything further in a preliminary status?
Nothing for the people, Your Honor.
Ms. Michelle?
None.
Okay, let's call the first witness then.
Your Honor, at this time, the people would call Michigan State Trooper Michael Sherry.
Sir, could you please state your full name, your first and last name? To Madam Court Reporter. Well, you can say that out loud to all of us because I'm going to write it down.
Detective Trooper Michael, common spelling Michael, Sherry, Sherry.
Thank you.
Could you hear everyone in this chair?
No, actually, we're using here now, but could you please raise your right hand? Do you solemnly swear or affirm testimony you're going to give is the truth, the whole truth, and nothing but truth?
I do.
Thank you, sir. You have a seat here. Madam Prosecutor, once he's situated, you may proceed.
Thank you. Good morning again.
Good morning, ma'am.
Could you state your name for the record again?
Michael Sherry.
And who are you currently employed with?
I'm the detective trooper with the Michigan State Police.
Are you specifically assigned to a specific unit at the front?
I am.
Which unit are you assigned to?
The Southeast Island 13.
And how long have you been assigned with that unit?
2.5 years.
And where were you assigned before that?
I was working out of the Metro North Post in Oak Park. Prior to that, I was working out of the Metro South Post out of Taylor, Michigan.
And in the course of your duties, were you dispatched on or about May 6th of 2017 to the area of the Davidson Freeway, just east of the I-75 overpass?
Yes.
And do you recall why you were dispatched to that area?
Yes, I was dispatched.
I'm so sorry, and I'm going to object to hearsay unless it is only being used for why the officer did what he did.
That is the only reason.
Please proceed. The objection is overruled.
Go ahead.
I was dispatched to a single car crash.
All right. And do you recall what you saw when you arrived at that scene?
Yes.
What did you see?
I observed on the north side of the Davison Freeway, there was an overturned car. It was a maroon four-door sedan. It was sitting on its roof. I saw several bystanders just north of where that vehicle was at final rest.
Did you come in contact with the operator of that vehicle?
I did.
And do you know the identity of the operator of that vehicle?
I do.
And what is that identity?
Miss Jantina Jackson.
I'm gonna have you stand up and look around the courtroom. Do you see Miss Jackson in the courtroom today?
Yes, ma'am.
And can you point to me and tell me what she's wearing?
She's seated to my left, wearing blue.
Your Honor, let the record reflect that the witness has identified the defendant. The record will so reflect. And how did you identify Miss Jackson?
Initially, I identified her verbally. I was advised by one of the other bystanders. She was.
I'm gonna agree with Ms. Michon on that. You can't tell me what you observed or heard from another person.
Okay.
Okay.
I identified her by her name and date of birth.
Okay.
I then confirmed her identity by going into my patrol vehicle, looking up her information in a database, and I reviewed the photograph that was listed through the Secretary of State for Ms. Jackson, confirming her identity.
Okay. And when you go into that database, does it tell you whether or not the individual has a valid driver's license?
The database I utilized at the time to confirm her identity was separate from actually running through the law enforcement intelligence network.
Did you run her through the law enforcement intelligence network?
I did.
And what did you learn after running her through the law enforcement information network?
At the time of the incident, her license was currently suspended.
Okay. And did you identify any other individuals or passengers of the vehicle at that time?
There were two other passengers in the vehicle. One was out of the vehicle, which was identified as Miss Jackson's daughter. And then there was another passenger that was still entrapped in the vehicle, and it was determined deceased, and that was Miss Jackson's other daughter.
Okay. And do you recall the name of the deceased individual?
I do not. I would have to refer to my report for the specific name.
Do you have the report with you?
I don't have it with me here. I left all my materials on my chair.
Your Honor, may I approach the witness?
Ms. Michon has seen it, correct?
Of course, and I would have no objection if you want to get.
Thank you.
Thank you.
Did you identify what I just handed you?
Yes, this is my incident report.
And does it indicate the name of the two daughters you indicated previously testifying to?
Yes, it does.
And what are their names?
The passenger that was not in the vehicle, I apologize if I'm mispronouncing her name, Josiah Winter Daleen Patterson. She was out of the vehicle, seated on the service drive north of where the vehicle was at final rest. The passenger that remained in the vehicle and was determined to be deceased was Jocelyn Marie Summer Patterson.
And do you have an age for Ms. Patterson?
The
At the
deceased,
time? Yeah, the deceased.
at the time,
If you don't, that's fine.
I do. At the time of the crash, she was 6 years old.
All right. And when you made contact with Ms. Jackson, did you have any observations regarding her demeanor at that time?
Yes.
And what were your observations?
Her her pupils were pinpoint, and she seemed somewhat lethargic or slow to respond to some of the questions that we were asking her.
And Trooper, how long had you been a Michigan State police officer at that time, 2017?
At the time of this incident, 4 years.
4 years. And had you encountered people who had been under the influence of drugs and/or narcotics and/or alcohol during your course of employment within those 4 years?
Yes. I also served 22 years in the military as a military policeman, and I had encountered people under the influence of alcohol and narcotics there.
Okay. And in your professional opinion as a Michigan State police officer and former military, were you concerned with what you testified to is the dilation of the pupils and the lethargicness of Ms. Jackson?
And actually, Judge, I'm going to object to that. I think we're going to need a better foundation. Obviously, under the influence of alcohol is one issue. Under the influence of, in this case, marijuana is something entirely different. If we can disseminate between the two,
I would agree.
You've had contact with, that would be wonderful.
I would agree. Thank you. I will. So in your professional opinion, as Michigan State Police, were you concerned that Ms. Jackson was under any influence of alcohol based on what you observed?
Alcohol, no.
Were you concerned with, based on your professional opinion, were you concerned or have any suspicion that she was under the influence of any narcotics such as marijuana?
And Judge, I'm going to object again. I think we're going to need a better foundation as to his prior contact.
Objection sustained. If you could lay a foundation with regards to this trooper's experience that would allow him to answer that question.
Okay.
Thank you.
So during the course of your employment as Michigan State Police, have you had training in identifying people who are under the influence of marijuana or narcotics?
Yes.
And what type of training have you had?
Throughout the Michigan State Police Academy, we received training on how to detect through body language, through responsiveness of the eyes, also through if we actually encounter someone that's operating a motor vehicle, how their motor skills are, either through field sobriety tests or through conversation questions.
And based upon that training and experience, did you have concerns when you arrived at this crashing scene today?
I did.
Or that day, on May 6th of 2017?
I did.
And what were some of the, I guess, what did you observe that led to these concerns?
Ms. Jackson's, her response to the questions that I was asking her.
What type of responses were those and what caused that concern?
They seemed delayed. Her responses had like a lethargy to them. She understood that I was asking her questions. She was looking at me, but her responses were delayed.
Okay, were there any other, I guess, tells that would cause you concern?
There was a faint odor of burnt marijuana that was emanating from her person.
Okay. And did you request did you perform a field sobriety test on site?
I did not.
Why not?
Because there was concern over Ms. Jackson possibly having injuries from the accident. At that point, the concern was for her safety over trying to provide any type of roadside testing.
Okay, and so what did you do based upon those concerns?
She was transported via EMS to the hospital for follow-up and evaluation. I went to that hospital, and that's where I continued my investigation.
Okay. I don't believe I have any further questions at this point.
Okay, before we switch to cross-examination, can we have this gentleman brought out?
Yes, DJ on YYYY call.
Is this Mr.
Okay.
Who's the prosecutor?
Oh. Mr. Boomer.
Mr. Bloomer's realized we were all.
Calling case number 21-58879, People versus Lawrence Robert Harris Weaver. Defendant is charged with count 1, motor vehicle, unlawful driving away. Count 2, domestic violence. Defendant is a habitual offender. 4th offense notice. Defendant is scheduled today for an examination.
Thank you. Appearances, please.
Jacob Bloomers on behalf of the people.
Scott, good morning to you. Could you put your appearance on, please?
Good morning, Your Honor. Wanda Kettle on behalf of Lawrence Weaver.
Good morning. Mr. Weaver, could you please state your name?
Lawrence Robert Harris Weaver.
Thank you. Today is the date and time set for preliminary examination. This matter was set for 10 a.m. It's currently 10:21. Are we proceeding to an examination today?
Your Honor, at this time, the complaining witness, Carla Mathis, is not present in the courthouse. She was subpoenaed to be here for a 10 a.m. preliminary exam. Without her present participation, the people are unable to move forward at this time.
Is there a motion? Thank you. Matter is going to be dismissed. Keep in mind, Mr. Weaver, that it's dismissed without prejudice. And what that means is that it is possible that the matter can be reissued. That's going to be within the discretion of
Possession of a stolen vehicle. That's the charge here.
That's going to be within the discretion of the prosecutor. If you have questions about the possibility of a reissuance, please make sure you speak to Ms. Cal. She will explain that to you in greater detail. There is a misdemeanor, correct?
Yes, Judge.
Count 2 is a misdemeanor. The felony is going to be dismissed without prejudice, but count 2, the misdemeanor, is going to be set for a pretrial. Would that be August 12th?
Yes, ma'am, Your Honor.
Yes, sir.
And I wonder why would that be when they've been holding on cases together? Why would I have to be held up any longer for something that I ain't did? And that they've been running the cases together since the beginning, why can't you hear heard today on the matter?
Very good question, but I have a jurisdiction over the felony, not the misdemeanor. Now, certainly, Madam Defense, I don't know if she was going to address bond. I don't know.
Yes, Your Honor. Since you dismissed the felony, we're asking if you grant him a bond.
Okay, the bond currently is set at what?
$5,000, 10%, Your
So what are you asking for?
Your Honor, my client was working prior to his arrest. He's not able to make that type of bond. It's a prohibited bond for him. Your Honor, I'm asking for a personal bond.
Mr. Bloomers?
Given that the felony is dismissed, the people would stipulate to a personal bond so long as a GPS tether is ordered.
Okay, looking at the original order, it does confirm that the bond is currently 5,000, 10%. I am going to amend that to a personal bond. That needs to be signed by Ms. Cal. I'm going to amend it to a personal bond with a GPS tether. You are to maintain the no contact provision with the complaining witness. You understand that, sir?
Yes, ma'am.
And your pretrial is going to be, again, August 12th before Judge Garrett.
Judge, can I get a different date?
Sure. What date would you like? August 11th?
Can I get August 18th?
August 18th it is.
Thank you.
Okay. We're all set here.
1 second when my client please.
No, I can't. If you can go downstairs, I'm taking them right now.
Just stay away from her.
Yes, ma'am.
Okay, we're back on the record in the matter of People versus Jackson, 180604446. Wait, strike that. Counsel, were you ready to put the waiver on, or did you have a concern?
Your Honor, we're ready to put the waiver on.
Okay, recall is People versus, what's the name of your client, Harris?
Deontay Harris.
Nancy.
Madam Corporal? Recalling People versus Deontay Harris, 200-616-14. Appearances again, please.
Good morning, Your Honor. Jacob Slusky on behalf of the people, P83677.
Good morning, Your Honor. Susanna Kostowski, P39535, appearing on behalf of Mr. Harris.
And Mr. Harris, please state your name.
Deontay Harris.
Okay, what's your pleasure?
Your Honor, Mr. Harris would like to move forward with the waiver of the exam.
Okay, Mr. Harris, I asked you, I think I got as far as the $1 million question is, do you still wish to give up your right to a preliminary examination?
Yes.
Okay, understanding that that means the matter would automatically be bound over to the circuit court without the benefit of an exam. Yes or no?
Yes. Yes.
Are you doing so voluntarily?
Yes.
Thank you. I do find your waiver to be knowingly and voluntarily given. I also have the examination waiver form that appears to be properly executed and returned to the file. The matter is now bound over to the circuit court for further proceedings with an AOI date of August 12th at 9 a.m. Anything further?
Nothing from the people.
Nothing further, Your Honor.
Thank you so much.
Thank you.
You can, Mr. Harris.
Thank you.
Thank you, everybody.
Yeah. Sanders, I was just letting you know that I need Ms. Cow's signature on the motion to reduce bond if she's still here.
Okay.
We're back on the record in the matter of People versus Jackson. This is 1806446. Appearances again, please.
Good morning again, Your Honor. Abigail McIntyre, on behalf of the people, P71143.
And good morning, Your Honor. May it please the court, Kim Michon, Neighborhood Defender Services, P59167, on behalf of Ms. Jackson.
Please state your name one more time.
Jackson.
Thank you, and I apologize for this back and forth, but this is the nature of, this is how the pandemic has affected things. We have to get things in when we can or we lose people. So with that being said, Ms. Michon, can you please pick up with the cross-examination of Trooper Sherry?
Absolutely. Trooper Sherry, a couple questions for you. In this particular case, you were testifying regarding your concerns about Ms. Jackson. Do you remember that line of questioning?
Yes, ma'am.
Now, and correct me if I'm wrong, Ms. Sherry was in the vehicle that was rolled over, correct? She was driving that vehicle that was in some sort of collision and ended up on its roof, right?
Yes, ma'am.
So she had just experienced a car accident, correct?
Yes, ma'am.
She had 2 children in that vehicle at the time of that accident, correct?
Yes, ma'am.
One of those children was on the side of the road with her, correct?
Yes, ma'am.
And the other had sustained catastrophic injuries, correct?
Yes, ma'am.
And I think it's fair to say had a blunt force trauma to the back of her head, and in fact, her head itself was actually outside the window, and she was deceased at the scene, correct?
Yes.
And your concerns about Ms. Jackson were that she had watery eyes, right?
I didn't state that.
Glassy eyes. Yes.
I didn't state that on the record. I don't know if you're referencing something in my report.
Did you indicate that you were concerned about her because she was lethargic?
Yes.
And that she was delayed in her responses to you?
Yes.
Okay. So those were the concerns you had, correct?
Yes.
We didn't do any field sobriety issues because at some point you were also concerned because she herself, having been in this accident, needed to be rushed to the hospital to have her checked out, correct?
Correct.
And one of those concerns about her physical health was conceivably if she had sustained a concussion in this accident, fair?
I guess that's fair to say, yes.
Which would have delayed any of her responses to your questioning, correct?
I can't comment to that. I'm not a doctor.
You rush her to the hospital based on what you're observing, correct?
Yes.
And one of those things that you're observing is that she's lethargic, correct?
Correct.
And one of the key problems with having a concussion is that you could be lethargic, yes?
If you say counselor, yes.
You have military service, sir. I'm sure you've seen people having concussions.
Counselor.
Your Honor, I'm going to object that it hasn't been established that he has the expertise or the training to establish what the symptoms or the, I guess, result of what a concussion
Objection
looks
sustained.
like. Objection
Very
sustained.
well. You were concerned about trauma to Ms. Jackson, correct?
And her daughter, correct.
So much so that you didn't perform any field sobriety issues, correct?
Correct.
And so the only testimony we have to go on is that she didn't answer your questions right away, correct?
Correct.
About how the collision happened, correct?
She answered questions to Trooper Meyer on how the collision happened. And then she answered questions to me when I followed up on the investigation at the hospital.
What questions did you ask her at the scene that she delayed her answers on?
I asked her for her name, her date of birth, basic information, if she was driving a motor vehicle.
And those were delayed, correct?
Yes.
She was, I'm sure, concerned about her dead daughter in the vehicle, yes?
The lethargy just wasn't in her response, but it was in her speech pattern. So it wasn't just that her response to my questions were delayed, it's her speech pattern as she explained and answered the questions.
Which, fair to say, you don't know if that has anything to do with marijuana in her system or injury sustained she had during that collision, fair?
Correct.
Or the trauma of one of her daughters being in the vehicle, dead, correct?
Correct.
And one, praise God, wasn't her, fair?
Correct.
Thank you, no further questions.
Any redirect? Yes, just a couple questions. So to follow up on Ms. Michon's line of questioning, you indicated that you did ask Ms. Jackson some follow-up questions at the hospital, correct?
Yes.
What were the natures of those questions?
After she was advised of her rights, I asked her questions regarding her operating the motor vehicle and the circumstances of the crash. I also asked her if she had a medical marijuana card.
And what was her response to that question?
No.
Did she ever indicate to you that she had used marijuana prior to the operation of her vehicle on that day?
She did.
And based on that answer, did you then request medical records or any labs to be done?
Yes.
And do you recall the results of those medical records or labs?
Yes.
And what are the results?
Her blood results came back with cannabinoids in her blood, and also in the medical records that we received from the hospital. It was positive for cannabinoids in her blood from the hospital records also.
And those were done on the day of the accident on May 6th of 2017?
Correct.
Okay, no further questioning.
Any follow-up? Thank you. In the second round of questioning, you asked the question and she gave the answer, correct?
Excuse me?
You asked a question. Did you receive a delayed response at that time? I'll take that as a no.
I don't recall.
Okay.
I recall her answers.
But you don't remember if that was delayed or not?
I don't recall specifically if there was any delay then.
But you recalled the delay at the scene, perhaps under the trauma of being in the accident, fair?
Yes.
Thank you. And presently, at least, small amounts of marijuana are legal in the state of Michigan, correct?
Presently, but not back then.
No, I understand that, but presently, they're legal. Yes?
Yes.
Thank you.
Okay, thank you, Trooper.
Thank you, ma'am.
Any further
No further
witnesses?
witnesses, Your Honor.
Madam Defense, do you have any witnesses?
Not at a preliminary exam.
Madam Prosecutor, well, I only ask as a matter of courtesy, I'm sorry. Prosecutor, do you have a motion?
Your Honor, the people would move to bind the defendant over as charged. You heard testimony from the officer that, or the trooper, I apologize, that Ms. Jackson was operating the license. He ran it through the lane at the time of the crash, that her license was suspended. We also presented the records, and her daughter was presented, was deceased at the scene of the accident, which was also confirmed by the medical records and the autopsy report. The people have established their burden as to count 2 of operating while intoxicated. Her medical records and the Michigan State Police labs indicate that she was positive for marijuana in her system at the time of the accident. And we've also met her burden as to child abuse second degree, which is causing serious physical, she acted in a manner to cause serious physical harm, which actually the death of a child, and she had another one in the car who luckily was on her at the time. The people have met their standard by probable cause and removed the defendant to be bound over to Lake County Circuit Court.
Ms. Michon?
We are going to object to the bind over, Your Honor, very succinctly as it relates to count 1. The defendant needs to be both the factual and proximate cause, the lack of license, right? It has to be the factual and proximate cause of the collision in this case. We don't know that based on this transcript. Secondly, as it relates to the final 2 counts, the issue is, was she under the influence, which then caused the death of the child, and that also forming the basis of the child abuse. In this particular case, Your Honor, the mere presence of marijuana in one's system does not necessarily mean that it caused the death of that child. In this case, the only influence we have is the trooper's testimony that she was delayed in her responses. We don't have any field sobriety issues in this case. And in fact, quite frankly, if I had experience with what Ms. Jackson had experienced, my pupils may be, pinpoint. I may be lethargic as a mother, and I may have delayed my responses on the side of the road with my child with her head hanging out that window. A horrible, horrible, traumatic experience. And the idea that we're going to now use that testimony to say that she was under the influence for both count 2 and 3, I think belies what the state legislature wants. And the mere presence of the marijuana later detected in her system, which I think presently in the state of Michigan would be legal, to now suggest that that forms the basis for this bind over. And that alone, I would object to, Judge.
Thank you. Before you respond, could I trouble you for the exhibits? I don't think they were ever published.
Oh, I apologize.
Your response?
Your Honor, I believe that there was testimony that there was a statement against interest where Ms. Jackson did admit to the trooper that she had been smoking marijuana prior to operating the vehicle. It was a single car collision that she was the driver, which was testified to. I believe that people have met their burden to show that, A, her license was suspended during a crash causing death, and that she was operating under the influence. It's a question of fact for the trier of fact, and it should be gone over.
Thank you. I've had an opportunity to listen to the testimony from Trooper Sherry. It's been presented by the prosecution, as well as to consider the exhibits 1 through 4. And with that, this is a probable cause hearing, Ms. Jackson. So the burden on the prosecutor is to establish by a probable cause standard only that crimes were committed in the city of Detroit County, Wayne, and that you probably committed those crimes. People often talk about how it's a low burden here. It is a much lower burden than is required across the street. And until things change, laws change, this is the burden that is deemed appropriate to determine whether or not a matter should proceed on. And probable cause is kind of a term of art that we use in the legal world, and perhaps can be further explained by your attorney as to what it is that this court must consider. But having heard the testimony and examined now the exhibits 1 through 4, I'm satisfied the prosecution has met that burden. There's a question of fact here that does exist as it relates to the allegations against you, counts 1 through 3. As such, I am going to bind over on all 3 counts for further proceedings with an AOI date of August 12th. We are on the record in this matter, so if you're in the courtroom, please make sure you refrain from talking if you're not on this immediate case. The matter is going to be bound over with an arraignment date of August 12th at 9 a.m. Is there anything further?
Well, Judge, I would ask the court to address Ms. Jackson's bond. I appreciate the fact that she is out on bond. That's a wonderful, wonderful thing. She actually turned herself in. She was residing down south, and once she found out that there was a warrant for her, she turned herself in. She's residing in the state of Michigan. There's no fear of her returning to former locations. She's employed here and has no prior convictions or anything, Judge. If the court would be gracious enough to remove the tether, I think we're looking at trying this case in 2 years at this point.
Madam Prosecutor. Your Honor, I believe, these are very, very serious charges. And I understand that there's been a length of time and she did turn herself in. However, there were 3 years between the time that she was charged and she did turn herself in. She does have ties to.
Wait, say that last part again?
Said it was about 3 years between the time that this matter was charged, the warrant was authorized, and she did turn herself in.
It was 3 years.
It was about 2. It was authorized in 2018. By prosecutors in a different unit at this point. And I believe it didn't come to light until about 2020. So it was about 2 years in between. She does have ties to another state, and people will think that based on the seriousness of these charges, which is operating while licensed, suspended, causing death, and operating while impaired, causing death, that a tether is sufficient bond.
Motion to remove the tether is denied.
Thank you.
Certainly that argument can be raised again when you go before the circuit judge. And I think we're all set here.
Understood. Thank you.
Thank you. Oh, can I trouble you to return these exhibits to Madam Prosecutor? Thank you. Thank you. Mr. Parker?
Do you need these with the transcript?
Are you?
Yes.
Oh, no, have we lost? Let me see. Oh, I think they're in a waiting room. Hold on.
Okay. All right, I appreciate it.
Okay, is this your client?
No, it isn't.
Deputy, who do you have there?
This is Grady here.
Vonshea Thomas.
Deputy? Oh, Vonshea Thomas, is that?
That's Ms. Coulter.
Ms. Coulthurst. Okay, did you want to call that?
Is she here?
I want.
In. Ms. Coulthurst, are you there?
Good morning, I am. Your Honor, he would like to speak with his attorney first.
Perfect. What's going on with Grady? What are we doing on Grady?
Grady, Your Honor, I believe will be a probably defense motion for dismissal.
Okay.
Calling case number 20-59143, People versus Landis E. Grady. Defendant is charged with count 1, weapons, firearms, possession by felon. Count 2, carrying a concealed weapon. Count 3, weapons, felony, firearm. Defendant is a habitual offender. Third offense notice. Defendant is scheduled today for an examination.
Thank you, sir. Appearances, please.
Good morning, Your Honor. Bryn Bailey on behalf of the people, P84009.
Good morning, Judge. Neighborhood Defender Service by Lauren Anderson, PA5191, representing Mr. Grady, who is the president of Court Smart.
Mr. Grady, please state your name.
Landis Grady.
Okay. Today is the date and time set for preliminary examination. Are we proceeding to an exam?
Your Honor, we are not proceeding to exam. People are unprepared to proceed. None of, the subpoenaed witnesses have arrived, Your Honor. They were sent subpoenas back in January of this year, Your Honor. They were also sent, reminder emails by myself yesterday and, have not made it to the courthouse.
Is there a motion?
Yes, Your Honor, this time we would move to dismiss the case.
Okay, it is currently 10:45 in the morning, and this matter was set for an examination at 10 a.m. with representations being made by the prosecution. I am going to dismiss, I'm going to grant defense counsel's motion to dismiss this matter. It's dismissed without prejudice. And what that means, when a matter is dismissed without prejudice, that means that it is possible that the prosecution can reissue. Most people don't understand that or really absorb that. So if you have a question about the concept of a possible reissuance, please make sure you speak to your attorney and she'll explain the parameters of that to you in greater detail. Okay?
Thank you.
Do you have on a GPS tether that needs to be removed?
No, I was released on personal.
Okay, thank you so much. I just need your signature, Madam Defense, on this order of dismissal.
Yes, ma'am.
And I think we're all set here. Anything else we can call? See Mr. Montgrady's here.
She is.
She's in the back. Mr. Montgrady, are you ready on your matter?
Yes, Your Honor.
Okay.
There is a co-counsel, Mr. Moxie.
He is in the hallway as well.
Okay, let me just ask, is Ms. Diallo present, officer?
Oh, ma'am.
Is Arnett a jailer?
He is.
Okay, can we have Arnett brought up? I'm assuming Ms. Diallo, when she gets here, she may want to speak with him in holding. I mean, is that okay, or? Okay, all right. So good morning. If Ms. Diallo is not here, then let's proceed with, Mr. Montgrady and Mr. Moxie. Yes, no?
Sorry,
We're getting ready to call, your case.
Yes.
And, I thought I heard Mr. Moxie's present as well, so.
He's in the hallway, yes, and the court staff is grabbing him right now.
Oh, great, thank you so much. Okay. Call Johnson and
Calling case number 20-61528, People versus Stephen Dawson and Christopher Johnston. Both defendants are charged with count 1, breaking and entering a building with intent. Count 2, burglars, tools, possession. Defendant 1 is a habitual offender. Court defense notice. Both defendants are scheduled today for an examination.
Thank you, sir. Appearances, please.
Morning, Your Honor, Jim Bailey on behalf of the people, P84009.
Morning, Your Honor. Andrew Moxie, P number 69568. I have defendant Christopher Johnson, who's failed to appear.
Okay, today being an exam date that was set for 10 a.m., it's currently 10:49. Is there a motion? Thank you.
Your Honor, at this time, the people would motion for capias on Mr. Johnston.
Okay, Mr. Johnston, I'm just gonna take a quick look at his bond. Do you recall offhand what his bond was?
Not offhand,
Have you had any communication with Mr. Johnston?
not recently.
Okay, thank you. So you have no reason to explain why he might not be here today?
No.
All right, I'm sorry for the delay. I'm just trying to make sure I can eyeball what his current bond was. Anybody, Mr. Clerk, do you know? Does anybody know?
I'm sorry, Your Honor. Yes.
This is a double bagger. I'm just making sure I'm looking at the right bond.
Mr. Johnston's bond was 2,500 personal.
Was he on a tether?
No, ma'am.
Okay, so again, he's currently 10:50 in the morning. The matter was set for 10 a.m. and there's been no reason offered to explain Mr. Johnston's failure to join us here at this party, which is unfortunate. I am going to grant that motion for a capias to be issued. Previous bond is revoked. New bond is, oh, I'm sorry, new bond is going to be set at $25,000 cash or surety. Mr. Montgrady, were you saying something about Mr. Johnson or?
No, I was, no.
Oh, okay.
I apologize for
That's what, Mr. Moxie, we're all set as it relates to Mr. Johnson. Now, in the event that you're able to get in touch with him, please let him know that a capias has been issued and what he needs to do in order to avail himself of this process now. Certainly, Mr. Sanders, I would imagine, probably won't enter the capias until what, about 2, 3?
Yes, ma'am.
So if you happen to get in touch with him sometime later today, you certainly are welcome to Zoom in and notify the prosecution, Zoom in, and we can get this back on track. But if it's after 2 or 3, then the capias will certainly have been entered into the system, and he should understand that there's an open warrant for his arrest.
Thank you, Judge.
And thank you so much. We're all set.
Could I ask you one question about another matter too? Could I approach?
Oh, yes.
Okay, thanks.
I mean, I'll unmute it, but not necessarily the same level of concern where we have a court reporter that's zooming in and can't hear us.
Okay,
But thank you though. Okay, is this the stand-in OIC?
Yes, ma'am.
Okay. Your name, sir?
Edward Davis.
Okay, I wanted you in here because there were some representations that were being made, and I want Ms. Bailey to start over with what she was saying, because it's important. It's an issue that I've seen come up. It's been brought to the court's attention a lot lately from defense attorneys. And they're coming here on their date for examination, and they have voids where there should not be voids, or there should be some representation that's definitive. So I just want you to be a party to this, even though I appreciate you are the stand-in officer in charge. There is some level of communication. There's a gap that's appearing, and there needs to be, I don't know, there needs to be a partnership, if you will, from the officer's perspective, so that we can all be on the same page. Mr. McGrady has expressed concerns that there were 12 officers, and she only has one body cam. There's mention that there's at least 2 videos, but she only has 1. Madam Prosecutor, if you could now repeat what you said before, because I want this officer to hear what you're saying.
So I have reshared with Mr. McGrady. Her only having 1, honestly missed my radar yesterday. But I remedied that situation. She has now the 2 that are available to me. Again, I don't know when she had them, when she didn't have them.
I'm sorry, if I can clarify, when you just say you reshared it, is that since we spoke in the hallway?
Yes.
Okay, thank you.
I have done that to ensure that she now has it. I myself reached out back in March. I followed up a week or 2 later. Ms. Yafufi reached out 2 to 3 times.
Reached out to?
The original officer in charge, Officer Buscemi.
Okay.
Buscemi, who is on furlough and vacation and is not present here today.
Thank you.
APA Ben Denowith also reached out at some point, I believe, in December, possibly early January. I never received any response back. Ms. Yafufi didn't receive any response back. My office has made additional attempts. I personally have reached out and called up the chain of command. My supervisors have also been involved in this. They reached out and made requests, Your Honor. At this time, the people are prepared to proceed to preliminary examination.
Okay.
The court rules indicate that discovery is ongoing and that not everything has to be turned over by the preliminary examination. Mr. McGrady has everything that the people are going to be relying on for this preliminary examination. Any deficiencies she believes may be in the evidence that she has is a matter for circuit court, Your Honor, and should be motioned in the circuit court as such.
Okay, so I definitely understand that. I appreciate that argument. But here's the thing. The concept of working or being cooperative with turning over discovery and or indicating if it even exists, if it doesn't exist, and if it doesn't exist, why it doesn't exist. That's just a matter of acting in good faith, whether you're defense counsel or prosecutor. It's just a good practice.
And
I understand you've indicated that there's no response, but Officer Buscemi has got to have a supervisor. There's a hierarchy in every field. There's got to be somebody over this particular officer's head. And the fact that you have reached out and your counterparts have reached out, that's good. I appreciate that. But that does nothing for Mr. McGrady. Now, can we proceed to an examination today? Yes, we can. But Mr. McGrady or any defense attorney is entitled to have an understanding, where are the other 10 body cams? Do they exist? Were they recorded over? Were they destroyed somehow? And if so, why? Was something malfunctioning? There's so many questions, and if the officer in charge fails to respond, then someone above the officer in charge needs to either have a conversation with him or respond on his behalf. It's a little upsetting and frustrating to have just no response. That would be different if you said, well, there's voluminous medical records. And the hospital is they're gonna need a lot of time. We have the exam, we've got our witnesses, let's go to exam, and let's deal with, issues that may be on the way later. But there's nothing that the prosecution is offering in terms of where or even if that discovery exists. So that's a little bit different.
And Your Honor, if I might, these additional officers, of the additional officers, I have the 12 to 14 total officers. 4 of them have written reports, Your Honor. I don't know if they had body worn camera. I don't know if it was on. I don't know who they are. I don't know who was doing what.
But why don't you?
Your Honor, I have what I have to go on. I've talked to the officer in charge, Officer Buscemi, myself. I asked him, and he said, I don't know.
He says he knows he can't answer?
I'm sorry?
He says he can't answer the question.
Basically, Your Honor, he told me that he downloaded everything that was available. I had Officer Davis, I had Officer Davis re-look and recheck everything. I had another officer re-look and recheck everything.
So Officer Davis, can I ask you a question? You're the stand-in. Again, I appreciate that, but as you've been officer in charge before?
Yes, ma'am.
Okay, so is it, if you as an officer in charge cannot answer those questions, who might one go to?
I would say a supervisor, but ma'am, in Officer Buscemi's defense, he's told me, I checked yesterday, he downloaded everything he had. Every video, every piece of video that he had, he downloaded. He also made a DVD.
Okay, so, and what would that be? 2 videos?
Yes, ma'am.
Wait,
fully shared with defense.
I was asking Officer Davis.
Yes,
So
ma'am.
it's the 2 videos?
Yes, ma'am.
And that's it?
That's all that I'm aware of.
So any additional officers didn't have body cam going?
I can't say if they did or they didn't. I don't know, ma'am. All I can tell you is I double checked, and I didn't find any.
Okay. Well, I think we've made a little bit of headway, Ms. DeMongrady, and I don't mean to, if I'm talking aggressively, I'm just trying to make heads or tails of this. And Madam Prosecutor, I definitely understand your position. We can proceed to an examination. But there still needs to be, if you happen to be one day on this side, you will definitely appreciate the fact that there are questions that need to be answered. And if not now, then when? Does she wait until circuit court to say, okay, I have no idea if they exist or not. Do they exist? Don't they exist? Now we're hearing from Officer Davis's lips that they do not exist. You've only got 2 videos and they've been tendered to you. And so what is your pleasure as it relates to the examination?
So Your Honor, that second video was just tendered to me probably 10 minutes ago. I don't even think it's arrived in my email yet. I've not gotten over. So I have not actually had an opportunity to look at that discovery.
Okay.
So the 2 body cams that do exist supposedly of the 12, they begin after my client is already detained. So it's like, I guess I hear them saying it was everything that's in the database, but I guess a further explanation as to, DPD officers are mandated by their own policy that they shall wear the body cam. And the statute, there's a preservation statute. When an investigation is ongoing, 30 days or until the conclusion of that investigation, right? So I am still left with questions, and I also have not even had an opportunity to, even though I did alert them that I only had 1 body cam, to even view that second one that, they're now acknowledging does exist.
Would you like an adjournment?
I would like an adjournment. Yes,
Okay, we're gonna give a new date. Mr. Clerk, I know that we're jammed. We don't have anything close. There's nothing close because we have to handle in custody matters. They take priority. So the date, brace yourself. It's not going to be nearby. But since it's a reschedule, Mr. Clerk, can you find something maybe mid to late October? That's really bringing it close.
Okay.
And actually, can I see the defense, prosecution, and Officer Davis closer? Yes. While you're trying to find a date.
How about October 21st at 9:30?
October 21st. I believe that works. You said that's good for you?
Yes, let me just double check quickly. I apologize. An exam in Judge King at 11, but I'll be available before or after that.
Okay, is 9:30 okay?
Yes.
Okay, so October 21st at 9:30 is going to be the in-person examination date on Dawson. And hopefully by then, you will have certainly had an opportunity to review the second video that was forwarded to you today. If there's any concerns in being able to play that video, please make sure you're in contact with Ms. Bailey and she'll assist you or resend it if necessary. That being said, is there anything further?
Nothing from defense, thank you.
Madam Prosecutor?
No, ma'am.
Okay, we're all set, thank you. Yes, I'm sorry.
Calling parties on Marcus Inman. Calling case number 20-57585, People versus Marcus Inman. Defendant is charged with count 1, police officer fleeing, 3rd degree vehicle code. Count 2, police officer assaulting, resisting, and obstructing. Defendant is scheduled today for an examination.
Thank you, sir. Appearances, please.
Lynn Bailey on behalf of the people, Your Honor, P84009.
Good morning, Your Honor. Angela Whitaker on behalf of Mr. Inman, P54944.
Thank you. And your client?
Your Honor, my client is not present today because my understanding is we were just getting a new date.
Oh, are you requesting to waive your client's presence?
Yes, please.
Oh, okay. Well, I do see that it's an examination, no?
Your Honor.
My prosecutor indicated to me that her witness was not going to be available, so we had contacted the court to try to get a new date, but I didn't hear anything else about that new date, so I jumped on today.
Thank you. No, that makes sense. I understand. So we need a date, a new exam date. Your client is out on bond, correct?
Yes.
And Mr. Clerk, what can we do?
How far do you want to go?
Well, honestly, I think we got to go with late.
The officer should be back, she told me the first week of August.
Okay, well, it's going to be in October sometime. Yeah.
But that's what we got.
October.
Late October, I think, is the earliest we should push this.
What date did we give the last?
We gave October 21st.
Okay, October 22nd.
October 22nd, is that date available in the morning?
That should be okay for the people, Your Honor.
At, what's that?
No, 9:30. 9:30, I'm sorry.
October 22nd at 9:30, Madam Defense?
Yes, ma'am, thank you.
Okay.
Thank you, Your Honor.
Thank you so much for zooming in, Madam Defense.
Thank you.
All right. Has Ms. Diallo arrived?
No, ma'am, no, Your Honor.
Okay, now when I ask that, are you sure?
We keep checking the hallway every few minutes.
I don't think we can miss this.
But the last time I said that on a different attorney, they said, no, I've been here.
People versus Troy Martell Davis. Defendant is charged with 1 count, carrying a concealed weapon. Defendant is scheduled today. Also calling case number 20-57239. People versus Troy Martell Davis. Defendant is charged with 1 count, carrying a concealed weapon. Defendant is scheduled for examination on both matters.
Thank you. Appearances, please.
Good morning, Your Honor. Bryn Bailey on behalf of the people, P84009 on both files.
And good morning, Your Honor, Sarah Kraus, P81830, also appearing on both files for Troy Havis. Your Honor, I was in contact with Mr. Havis yesterday. I did speak to him, had a long conversation about his cases. He indicated he was going to be here this morning, so I cannot explain his not being here.
Okay, this matter was set for 11 a.m. It's currently 11:17 by the court's clock. Mr. Sanders, have we received any phone call from Mr. Havis?
No, ma'am, Your Honor.
Is there a motion?
Your Honor, the people would motion for KPS at this time. However, in effort for a full record, the people did not have witnesses here today. At this time, I don't have an explanation as to why, but given Mr. Davis's non-appearance, I would be requesting KPS.
Okay, I am going to issue a KPS. However, Ms. Kraus, if you are able to get into contact with Mr. Havis before, I'd say maybe 2, you can certainly zoom in, have him zoom in yourself, and make the motion. Just make sure that Ms. Bailey is also present to make a record, but you can certainly make a motion to dismiss as witnesses have failed to appear. But the prerequisite to making that motion is that we have, at least by way of Zoom, your client.
Understood, Your Honor. I will try to contact him again. I have attempted this morning, but have failed, so.
In the event that it is after, say, 2:30, the KPS will be entered and he will need to avail himself of that open warrant in the normal course of action. Okay?
Thank you, Judge. Thank you.
Oh, I should state this, I'm sorry. His previous bond is revoked, and his new bond is going to be set at $5,000 cash or surety on each.
Thank you, Judge.
Thank you. Do you have a KPS? Oh, I found one.
I have it right there.
Oh, you did?
It should be 2.
This is not one.
There you go.
Thank you.
2 perfect.
Ms. Hanson?
Yes, sir.
You're over here.
Okay, let's call Ms. Yancey.
Okay. It's at 2:39. This read is in the hall. She's coming in.
Oh.
Mississippi.
Good morning.
Good morning to you.
Thank you.
We're bringing in this.
What happened to Whitaker?
We just did that one.
Oh, we did that one, that was the adjournment.
Yeah. The only thing we have left is these 2 cases.
We'll get it to you.
We have Mr. Parker's matter, and then we have, was Jones coming back this
Ms.
afternoon?
Coulters, were you ready to go back on the record in your matter?
Yes, Your Honor.
Do I have that file?
No, I got it.
Okay, you can just recall it.
Recalling case number 2056038, People versus Vontae Thomas. The defendant is charged with count 1, malicious destruction of personal property, $1,000 or more but less than $20,000. Count 2, disturbing the peace. Also calling case number 1855769, People versus Vontae Thomas. Defendant is charged with count 1, larceny in the building. Count 2, embezzlement, agent or trustee, $200 or more but less than $1,000. Defendant is scheduled today for a tether violation.
Thank you. Appearances, please.
Good morning, Your Honor. Bryn Bailey on behalf of the people, P84009.
Thank you.
Good morning, Your Honor. Jennifer Colthurst, P52876. I appear on behalf of Mr. Vonshay Thomas.
Thank you. Mr. Thomas, please state your name.
Vonshay Thomas.
Okay. Counsel?
Your Honor, apparently we're here for a tether violation. I did receive the report. Waive its reading, stand mute.
Okay. What's, Madam Prosecutor, what are you seeking here?
Your Honor, I seek an increase of the bond from I believe 10,000 personal to 10,000 cash or surety, Your Honor.
What is the violation that's alleged?
That the device shut down and the defendant was unreachable at any listed numbers by the tether unit.
Now, when you say shut down, do you mean that what do you mean by that?
Your Honor, that's what I have. I believe that that would indicate that the device died and did not have sufficient charge.
Ms. Colthurst?
Your Honor, I'm respectfully requesting, Your Honor, to please allow for the reinstatement. I'm respectfully requesting, Your Honor, to please allow for the reinstatement of the $10,000 personal bond. My client had the misfortune of, number one, he missed his court hearing date because he had some type of glitch in his device and he was not able to get through. He did advise me that he made attempts to contact me on the 15th of July, but to no avail. Secondly, Your Honor, my client also indicated that he had no knowledge of the tether officer with whom he is supposed to communicate, and he was unaware of his need to stay in touch with the tether officer. As to the allowing the device to, I guess, not remain charged, there was some issue that arose at his former address, and consequently he had to leave the Fenton Street address. However, he now has a good address with a sibling. His current address at which he can be tethered is 16900 Santa Rosa in Detroit, 48221. And a good phone number is 313-401-6113. 313-401-6113. Unfortunately, you know, he wasn't able to maintain the old phone, and therefore he missed any opportunity to receive the message from the tether agent who made a number of attempts to reach out to him.
Why did he not start?
I'm sorry, I did not hear the question.
I mean, the root of the allegation is that the tether shut down, and so I want to just get right to it. Why?
Your Honor, when he had to leave the Fenton Street address, you know, there was a moment there where he was, you know, sort of without appropriate shelter. However, he now has appropriate shelter housing with his sister. I did speak with his mother. She confirmed that he's staying with a sister on Santa Rosa at that address. They have electricity at that address. He'll be able to make sure it remains charged up. He also has a job at the corner car wash, Timmy's Car Wash at 6 Mile in Santa Rosa. And that car wash is a structure that also has electricity. So if he needs to take a moment to charge up his device, he will be able to do that.
Okay, are you still trying to take, or is your client still trying to take advantage of the offer that was made by the prosecutor?
Yes, Your Honor, and hasn't been able to work consistently, but yes, it is his goal to take advantage of the offer. He just needs time to save up close to $5,000. He's not making a large amount of money at the car wash washing cars. However, he wants to be able to have the opportunity to take advantage of that offer. He's just going to need a substantial amount of time to save up the money.
So August 16th, so is August 16th not a realistic date for the return? That's what I have in my file.
Your Honor, it's not realistic. No, it's not. He's a father of 4 children, and so he needs to make sure they're fed. And
how long can that offer open? I mean, I'm kind of going back to like the original issue, which was that there was an offer made and I wasn't privy to that offer. So I'm just kind of addressing that now. There's a PCC set for August 16th. My notation is that we set it out again because the defendant needed an opportunity to come up with the money. So is that going to be open?
Your Honor, I would need time for that. I'm not aware of any offer at this time. I was presented with this tether violation this morning, and don't have access to my internal servers or databases to find any notes.
All right, okay, well, we're gonna keep it on track for August 16th as a check-in date. I'm going to deny the motion by the prosecutor to impose $10,000 cash assurity on each. I'm going to reinstate the previous bond, which was $10,000 personal on each with GPS tether. You have to adhere to the GPS tether. You have to adhere to the conditions of the tether, Mr. Thomas. You have to ask questions that you know, so you don't find yourself in a situation like this. And you have to have a verified address. So Ms. Coulthurst has already indicated that you do have one to provide to the tether unit, and that is where we are right now. Is there anything further?
No, Your Honor. Thank you very much.
Your Honor, just from the people, I will look into the offer that was mentioned here on the record to determine how long the people are willing to leave that offer open.
Okay, thank you. We're all set, Ms. Coulthurst.
Thank you very much, Your Honor. Have a great day, and staff, everyone.
Marquise
Deputy, do you have Marquise Alexander?
Yes, we have Mr. Franklin. This is Mr. Alexander coming to the chair now.
Wait, I'm sorry. Can I also ask you to contact? We're gonna have to hold on that tether violation. Ms. Diallo?
Can you hear me, Judge?
Yes, ma'am. Hi. Hey there, I thought do we have an in-person examination today?
Absolutely. I did email your, oh, Tammy's not there. Oh, no wonder. So I emailed this morning, and when I called assigned counsel or emailed them to let them know I am immobile, I am not going to be getting around for a few weeks in person. So unfortunately for this case, it was set for an exam, and I did email Ms. Jones earlier this morning. My apologies, Judge. I guess I should have zoomed in.
No worries. So your is right here. We're going to bring him out and call the case.
Hey, thank you.
Calling case number 1588893, People versus Edward Bruce Arnett. Defendant is charged with count 1, carjacking, count 2, stolen property, receiving and concealing a motor vehicle, second or subsequent offense notice, count 3, police officer assaulting, resisting, or obstructing. Defendant is an habitual offender, fourth offense notice. Defendant is scheduled today for an examination.
Thank you. Appearances, please.
Good morning, Your Honor. Fran Bailey on behalf of the people, P84009.
Judge, good morning to you and your staff and to Mr. Arnett. Lillian Diallo, P52036, appearing at this time. May I, Judge?
Please state your name, sir.
Oh, Edward Arnett.
Thank you. Madam
Yeah.
Defense?
Thank you, Judge. So by way of background, this is a carjacking case. I did have a visit scheduled with Mr. Arnett. They canceled my visit, have not rescheduled my visit as of yet, and I am immobile. I will not be able to get down to the court physically for about 3 weeks now, at least 3 weeks. So I did reach out to your court this morning in the 8 o'clock hour because someone was going to cover it. That fell through. And then I did reach out to assigned counsel and indicated to them that they should reassign this case expeditiously, but they needed to hear from the court first. And unfortunately, I didn't know Ms. Jones was not there. So that was the missing link. And that was me not doing the due diligence that is required.
No, but that's okay. Now we all are on the same page. So Mr. Arnett needs a new court appointed. Is that?
Yeah,
you make a
that's correct. Yes, I did talk to, I reached out this morning to let them know of that as well. And I do apologize to Mr. Arnett, but there's no way I can be over in that courthouse for at least 3 weeks, at least.
So can you contact for a new court appointed attorney? And Mr. Arnett, we're going to connect you with that new court appointed. I think the prudent thing to do would be to set this for a new PCC so that that attorney who is assigned can meet with you and get all of the discovery from this that can be resent or sent from Ms. Bailey. Today is the 22nd. We'll set this for a PCC on perhaps the 28th, Wednesday the 28th, July 28th for a new PCC.
And Your Honor, if I may, I'd like to address bond.
What?
Okay.
Your Honor, I don't see the amount of bond listed on the electronic ROA. I do see that it is at 10%. However, Your Honor, given the severity of these charges, and speaking with the complaining witness who did suffer some injuries, Your Honor, some extensive injuries that have still plaguing him to this day. And taking into consideration the defendant's past, I would be asking that the court raise the bond to a higher amount with no 10% provision.
Judge, may I? So Judge, that's a futile act I think Ms. Bailey is engaging in, right? He's currently incarcerated. He cannot meet that bond. I will not be the attorney on the case if I don't think it's appropriate to proceed to try to raise the bond that he already cannot meet for whatever reason she's talking about. Apparently it's sufficient to do what she wants done, which is a remand, I guess, status. He hasn't posted it. He can't post it. And I would ask that the other attorney be allowed to argue more effectively for Mr. Arnett.
What I did notice, it looks like it's a $25,000 10%, and I'm not certain why under these allegations that he's facing, count one being life, I don't know why the bond was set so low, but there is not even a GPS tether that was ordered.
Well, Judge, can you address that at the PCC, please, so the other lawyer can, argue effectively for that? I think it'd be malpractice for me.
This is what I'm going to do. Instead of the 28th, we're going to set this for a PCC tomorrow. Court appointed will be calling back or zooming in, presumably in a few moments. So we're going to see you on Zoom, Mr. Arnett, tomorrow. Okay? And that's July 23rd at 8:30 for new PCC. Once we get word, which should be in just a few moments, as to who the new court-appointed attorney is, Ms. Bailey, if you could not only send a discovery, but also send a smoke signal about your motion you're going to make to increase the bond.
Yes, Your Honor.
So that whomever that is not going to be caught like a deer in headlights.
Yes, Your Honor. As soon as Mr. Sanders and the court find out who this new appointed counsel will be, they will have discovery and my notification immediately.
Thank you. Okay, we'll see you on Zoom tomorrow, Ms. Burnett. Thank you, Ms.
Thank you,
Diallo.
Judge.
Well,
Judge, did you say smoke signal? Did I hear you say a smoke signal?
I literally said smoke signal. Those were the words that came out of my mouth.
Oh, everybody take care. Have a good day.
You too. Be well. Okay, what do we have before us? And how many witnesses is it? How many witnesses on the matter that's in the courtroom right now?
Your Honor, I believe this is going to be a waiver and a capias.
Okay. Let's go.
Is that correct? Okay.
Calling case number 20-61684, people. Calling case number 20-61684, people versus Tyrone Deshaun McLean Lott and Jason Dewan Mahan Jr. Both defendants are charged with count 1, motor vehicles operating the chop shop, count 2, stolen property, receiving and concealing $20,000 or more, count 3, stolen property, receiving and concealing a motor vehicle. Defendant 2 is also charged with count 4, stolen property, receiving and concealing $20,000 or more. Both defendants are scheduled today for an examination.
Appearances, please.
Good morning, Your Honor. Jacob Slosky on behalf of the people, P83677.
Good morning, Your Honor. Please assemble court, Kathleen Cherie on behalf of Tyrone Lott McLean.
Good morning. And your client?
I'm sorry, Judge.
And your client, before we pivot to the next account, defendant number 2, is your client present?
My client is unexplainably not present, Your Honor. This is very odd because I've talked to my client upwards of 15 times during this hearing. I've sent him the discovery, we reviewed it together. I'm not sure what error has been made in his mind that he is not present, but I'm certain I will be walking him back in or zooming him back in very shortly.
Can I have a KPS form, please? Is there a motion?
There is, Your Honor. The people at this time move to issue capias.
Thank you. It is currently 11:39 by my watch, and this matter was set for an examination at 11 a.m. And have we received a phone call from Mr. McLean Lott?
No, ma'am, Your Honor.
That being said, I am going to grant that motion for capias. Capias will issue. What was his previous bond?
It was
$3,000 personal bond. That previous bond is going to be revoked. New bond is going to be set at $5,000 cash or surety. And pleasure to see you, Madam Defense. Oh, we likely will not be entering this, Mr. Sanders, I believe, until about 2:30.
yes, ma'am.
So if you're able to procure his presence, you certainly can zoom in, and we'll try to get in touch with Mr. Slusky and get this back on track. Obviously, we won't be able to proceed to an examination in this matter today, but certainly we can get it back on track. It won't be entered till roughly 2:33. After it's been entered, however, he will have to avail himself in the normal course with an open warrant, okay?
Thank you.
Okay, thank you so much. Madam Defense.
Good morning, Mayor. This Honorable Court, Mary Ellen Yancey, P70750, on behalf of Mr. Mahan, who is also present in the courtroom.
Thank you. Please state your name, sir.
Jason.
A little bit louder.
Jason.
Thank you. Are we proceeding to an examination today?
We are not, Your Honor. I have had a conversation with my client for the purposes of today's examination. After discussing it with my clients and with my client in detail, we have decided to waive this preliminary exam.
Any objection, Mr. Prosecutor?
No objection, Your Honor.
Okay. Mr. Mahan, I just need to ask you a few questions, sir. Do you understand the allegations against you?
Yes.
Do you understand that you have a right to a preliminary examination?
Yes.
Do you understand that if an examination did occur here today, prosecutor would need to establish by a probable cause standard only that crimes were committed in the city of Detroit, county of Wayne, and that you probably committed those crimes. Do you understand that?
Yes.
And if they were able to clear that hurdle, the matter would then be bound over to the circuit court. Do you understand that process?
Yes.
The representation having been made that you wish to waive your right to a preliminary examination, do you understand that that would mean that this matter would automatically be bound over to the circuit court for further proceedings without the benefit of an examination here today?
Yes.
And is that still how you wish to proceed?
Yes.
Has anyone threatened or promised you in any way?
No.
Okay, thank you. With that being said, I do find your waiver to be knowingly and voluntarily given. The matter will be bound over to the circuit court for further proceedings with an AOI date of August 12th at 9 a.m. Is there anything further?
Nothing from the people.
Nothing from the defendant, Your Honor.
Thank you. Oh, I just need the examination waiver form to be reviewed and signed. I handed it to Mr. Clerk, who will hand it to you in a moment.
Thank you, Your Honor.
Thank you. Pleasure to see you, Ms.
You
Yancey.
too, Your Honor. Stay safe.
Thank you, Bob.
Mr. Sanders, can you hand that to defense counsel so that well, hold on.
Oh, Mr. Chambers is one of you.
Oh, great. Okay, so, Ms. Bailey just stepped out. Okay, Ms. Reed, are you supposed to? Yes. Hi. I'm letting Mr. McLean Lott in. He's connecting audio. Oh, can I have that file back? I'm sorry. This is, we're still on the record, if you will, in the matter of People versus Tyrone McLean Lott. Just a few moments ago, sir, we called the case and you were not here inside of the courtroom, which is where you're supposed to be. We do see you now on Zoom. Can I have appearances again, please?
Good morning, Your Honor. Jacob Slosky on behalf of the people, P83677.
Good morning again, Your Honor. Kathleen Sharita on behalf of Mr. Tyrone Lott, who is present via Zoom. He did indicate, I was calling and texting during the hearing, that he's been on Zoom since 10 o'clock. He said he wrote it down wrong. He wrote it as Zoom, not
And I understand the confusion that is, there's ample room for it during this pandemic, trying to figure out if you're supposed to be in court on Zoom. So I get that. But now that we have you here, and I appreciate you, sir, zooming in to let us know what the confusion was. Could you please state your name?
Tyrone McLean Lott.
Okay, Madam, thank you. Madam Defense, what is your pleasure in this regard? If you wanted to waive exam, that's one thing, but if you still want the in-person exam, then we need to set a new date. What I'm not comfortable doing is a hybrid, where you're here and he's there and witnesses are brought in.
I would like an in-person exam, Your Honor, and I do appreciate that because sometimes I like to kind of lean over and
communicate.
Yes.
Okay, so Mr. McLean Lott, we are busting at the seams. In terms of availability, it's just not, it's not around the corner. So, Mr. Clerk, can we find the first of, I think late October is going to be super close. But if you could find a date in late October, given the fact that Mr. McLean Lott is not in custody.
How about October 27th at 10:30?
Works for the people.
Works for the defense.
Okay, October 27th at 10:30 is going to be the new in-person examination date. Madam Defense, in the interim, if you happen to change your mind and wish to waive or have any other issue between now and then, please just alert the court and the prosecution and we'll tee it up.
Thank you.
Okay, I do also want to state on the record that people do expect to add a count of felony firearm at the exam. So I just wanted to let you know that while we're on the record.
Thank you. You did email me that as well, so I was aware.
Okay, thank you. We're all set. You can log off now, Mr. McLean-Lott.
Okay, so October 27 at 10:30,
Yes, sir. In the courtroom. In the courtroom.
36th district, right?
Yes, sir. Courtroom 233.
Room 233.
Yes, sir.
Okay. All right, thanks.
Thank you, Your Honor.
You're welcome. Pleasure to see you.
Thank you all.
Mr. Chambers, good morning, and thank you so much for zooming in. So we have a situation, Mr. Arnett was represented by Ms. Diallo, and Ms. Diallo is going to be immobile for about 3 weeks and is unable to handle this in custody matter. Mr. Arnett is no longer in the courtroom. He's aware of what's going on, and we set this for a new PCC tomorrow via Zoom. Are you available?
I'll make myself available.
And one other thing I want to mention to you, I know we're off the record, Madam Court Reporter, I apologize for not clarifying that. Ms. Bailey said as soon as she knew who the new court-appointed attorney was, is that her coming in? That she would forward discovery to you straight away. And she's also going to be making a motion, a bond motion to increase the bond. And I just want to kind of put you on notice. I wish she would come in, but she's in the hallway. I just want to. Pardon?
Is Mr. Arnett in or out of custody?
He's in custody with a $25,000, 10% bond on a carjacking. And Ms. Bailey is, I hate to hold you up, she hasn't re-entered the courtroom yet, but we're going to make sure she knows that she needs to forward that discovery to you. And are you available to Zoom in sometime tomorrow?
I mean, yeah, I'll make myself available. I'm in multiple courts. I'll do it. I'll get it done.
Okay, thank you. I think we're all set unless you wanted to talk to Ms. Bailey. She just hasn't re-entered the courtroom yet.
No, I would ask, has there been a PSI done? I mean, a DSV done? I'm not asking for one, but I'm just curious, has one been ordered?
Can I see that file?
And I'm not asking for one, but I know that they.
Oh, I got it, Mr. Sanders. Let me see. No, there was no DSU report that was sought.
All right. I'll be here tomorrow. I'll talk to my client.
Okay, thank you so much, Mr. Chambers. We're gonna let Ms. Bailey know to send the discovery to you like straight away, like right out the gate.
I appreciate it. Thank you. Have a great one.
You too.
Yep.
Just the last one. No, we got two more. This is a tether violation. We got Mr. Franklin.
Do we have the prosecutor in the courtroom on my case? I can't see your courtroom fully.
Yes, he's here.
Do you know what cases they are?
We're gonna wait till the judge come back in to address that.
Okay then. I thought I wanted to make sure that my list is what you have, that type of thing. While we got a minute, can we do that?
Mr. Bloomer?
Yeah, so I got 3 cases. One of them is general warrants, so only 2 of them are mine, but there's
The 2019 case, which is 1905-9801, and that is the home invasion third degree.
Okay.
And, okay.
I have that one. Go ahead.
Then there's the 2020 case, which is 2005-8181, and that is general warrants, and that's a home invasion first degree.
What's the date on that? Do you have an information date?
Offense date is 6/25.
Okay. Of 2020.
Yeah, and that was the one that was in King, and then he was Caseus, and then they moved it here.
Okay, then. So we're all set then.
Well, then the last one is the 2021 case.
Right. What is that date? Is that 2/6?
Yes.
All right. We're all set. Those are the 3 cases.
Okay, great.
Okay, did we figure everything out, Mr. Parker?
Yes. What I like to do, we have the 3 cases. There are 3 felony cases. And I like to set a preliminary examination date for those 3 and do it all at once.
Judge, would you like Mr. Franklin in the chair?
Please, that would be great. Thank you so much.
Thank you.
Okay, I'm gonna hand this back to you. This is a recall of People versus William Franklin. And it's case number 19059800101, 21055778001, and 200588181. These matters were all formally called earlier. Appearances, please.
Jacob Bloomers on behalf of the people, but I do want to point out on the 2020 file, I'm just standing in. That is general warrants, but Ms. Bailey's away, but I think I can handle.
Thank you.
And good afternoon. May it please the court, or very close to the afternoon. May it please the court, James Parker, NDS Detroit, on behalf of Mr. William Franklin, P53832.
Thank you. And Mr. Franklin, I see your hand is raised. Can you state your name?
Yes, William Franklin. I would like to talk to my lawyer, please.
Oh, okay. I'll put you in a breakout room.
Yeah.
Yes, sir.
What time was the party supposed to be back on Simone Jones?
12. What time is it now?
Okay, because the county is all back in now. They just.
Oh, great. Okay, and I just before we call that, I think I have it though, don't I?
Yes, ma'am.
Okay. Recalling People versus Simone Jones, 21059370. This case was already formally called. Can I have appearances again?
Good afternoon, Your Honor. Ryan Elsey appearing for the people. My P number is 81329. I don't believe we have Mr. Johnson back, though.
Oh, right. I called it prematurely.
I'm ready to go now, Your Honor.
Okay. Mr. Elsey, as soon as Mr. Johnson appears in Zoom, we will pick back up.
Okay, thank you, Your Honor.
Recalling People versus William Franklin, 105577-801, 200-58181, and 19059-801. Appearances again.
Jacob Bloomers on behalf of the people.
NDS Detroit by James Parker on behalf of Mr. William Franklin.
Okay, Mr. Franklin, please state your name.
Yes, William Franklin.
Thank you. Okay, what's your pleasure here?
Your Honor, I talked to the prosecutor. Now, we're in agreement with the cases that are outstanding. In terms of the case numbers that the court called, I'm not 100% sure if those case numbers match with what the prosecutor believes to be the 3 outstanding felonies. But I don't know if that's something we can just take care of later or what. But what I would like to do is put all 3 matters, all 3 felonies for a preliminary examination on the same day.
Okay. Your client is in custody.
That is
correct.
Judge, I think I have a matter we have to address before we set the dates. So the 2019 case and the 2021 case, those were both up in this courtroom on 4/13, and he was capious in both matters. And then the 2020 case was up in King on 5/25, and he was capious in that matter as well. He has only been arraigned on the bench warrant in the 2019 case. So the other 2 are still in warrant status. The
So you would need to go before the magistrate on those, correct, Mr. Sanders?
Your Honor, I believe that these cases have been set for preliminary examinations. I don't know, you have to go before the magistrate again, but I leave it to the court's discretion. But I didn't know if you knew that we had preliminary exam dates on all of these cases.
Yeah, it's the bench warrants that he hasn't been arraigned on.
Okay,
I
so
see.
what would you do?
Well, I guess we just need to know it because there's no bond in those other cases because he hasn't been arraigned on the bench warrants.
And what would you like me to do?
Well, I guess I would ask for 50,000 cash on the. I believe 50,000 cash is what was set on the 2019 case when he was arraigned by the magistrate on July 13th on that bench warrant, and so I would ask for the same bond on the other 2 cases.
Mr. Parker?
Your Honor, I've talked to my client, Mr. Franklin. Mr. Franklin has indicated to me that he's always been trying to keep in compliance with his tether and that he has 2 jobs. And any additional information, I'm asking the court to specifically ask question Mr. Franklin about that situation.
Pardon? Wait, what do you want me to ask him?
About his job situation. He informed me that he has 2 jobs and he's always been in compliance with his tether.
Well, he's been capious. And that's why he's in the has he not?
Yes, Judge.
Oh.
There were, and to be clear again, there are 3 cases here. 2 of them were April 13th capious in this courtroom, and then on a different date in May, that 3rd case in King, also capious.
Oh, okay. So I do appreciate that he's been employed, but he's got some very serious allegations that he's facing, and I am going to impose $50,000 cash surety bond on all 3 matters. There's a lot of confusion going on, to be honest with you, regarding what has been done, what hasn't been done. So across the board, $50,000 cash and surety on each of these 3 files. We'll set an in-person examination date. Can you find a date that makes sense? I suppose we should be looking for an afternoon, Mr. Sanders, if you can find the first afternoon available for this in-custody exam. Did you have a question, Mr. William?
Mr. Franklin would like to address the court, please, Your Honor. Could we have him say what he needs to say before we can? Go ahead, Mr. Franklin.
Your Honor, I have really been trying to comply with the tether regulations, but when I call the court or whenever I call my tether officer, I'm always getting the operator. I'm never getting a straight answer on anything because it keeps sending me to the operator. And whenever I call my tether officer, it says go straight to the operator. It never lets me talk to my tether operator. And then when I call the court, I'm either not on docket or they don't know when I'm supposed to be in court. And I have not got nothing in the mail to say when I didn't even know nothing about no warrant or nothing, ma'am. So it's not like I'm trying to dodge y'all. I haven't had anything, to let me know what's going on. And every time I call the court or the tether officer, there's always giving me the runarounds or sending me to the operator to leave a message, which I continue doing, but I never get a response.
Okay, so I can appreciate.
She has that.
But can I say so? You were here on March 29th.
I was where, Your Honor?
We're in the Zoom. You were on Zoom.
Yes,
March
I was on
so
Zoom.
You were aware of the date on March 29th. You were aware that you had to be in the courtroom on April 13th. So that's the concern. That's the concern.
I'm not sure. To tell you the truth, I really did not know because when I contacted my attorney, he told me I was supposed to be there. I really did not know I was supposed to show up in person because of the pandemic. I didn't know if they was open or not because they keep sending me to the operator. I never can get a straight answer, Your Honor.
This is what I'm going to say again. On March 29th, you were in the Zoom gallery. Okay? We set an exam date of April 13th. Wait, I'm sorry. Let me just be clear.
Yep.
On March 29th was your exam date. You did not appear in person as you should have, but you did appear on Zoom. So I gave you a new exam date of April 13th, for which you did not appear. That is why we are addressing this matter like this, sir.
Yes, ma'am. Okay, so what I really want to say is the last time I talked to y'all in court, y'all said I was supposed to be there and I had to get there that day. I didn't know that I was supposed to appear in person that day because of the pandemic. I really did not know, and I'm not trying to dodge y'all. I've been trying to comply with each other.
You're talking about something that's a non-issue. Because we talked on March 29th, and because you appeared on Zoom and I realized it was obviously a mistake, I gave you a new exam date. And you did not show for that second exam date. So the bond is going to be $50,000 cash and surety on each of the 3. You've got 3. You've got 3. You've got 3 files before the court. Bond is set $50,000 cash and surety with no contact provision and GPS tether in the event you post bond. We are finding a new exam date. A new exam date is going to be September 17th at 1:30 to handle all 3 felony files.
That'll be a good date, Your Honor. I'm ready.
Perfect.
Thank you, Your Honor.
Thank you, Mr. Parker.
That was the 17th?
September 17th at 1:30.
All right, thank you, Judge.
For all three.
Yes.
All three cases.
Yes, sir.
All right, then.
Recalling People versus Simone Jones, 2105937. This case is already formally called. Can I have appearances again, please?
Good afternoon, Your Honor. Ryan Elsey appearing for the people, P81329.
Good afternoon, Bertram Johnson appearing on behalf of Simone Jones, P46646.
And Mr. Jones, please state your name, sir.
Simone Jones.
Thank you. Okay, we are back on the record in this matter to address the concern that Mr. Prosecutor brought forward and his motion to revoke Mr. Jones' phone privileges. Mr. Prosecutor, would you like to pick back up with, I have had an opportunity to read the summary that was forwarded to me. Would you like to pick back up with your motion, sir?
Yes, Your Honor. So based on the content of the calls that I provided and the overall circumstances of this case, just to give a little background about the circumstances, the defendant is alleged to have shot and killed a man by the name of Christopher Wilson outside of a house. The sole eyewitness to that shooting was also shot during the course of that, and that is Mr. Wilson's brother, who is named as a complainant for purposes of the AWIM count in this case. I believe that the circumstances of this call, of these calls, make clear that the defendant has been attempting to use an intermediary to contact the surviving victim in order to ensure that he does not testify against him. He doesn't say that in so many words, but I believe the implication of that is clear. There's an obvious nexus to these very court proceedings, that there's a remark that the defendant isn't going to take this to trial, that he doesn't want these people to come to court, that he doesn't want his name involved in this. And as a result, I believe that these calls establish very clearly that the defendant has used the phone system at the Wayne County Jail to commit another felony while he's been incarcerated, and specifically MCL 750.112 subsection 6 makes it illegal for someone to, among other things, attempt to willfully impede, interfere with, prevent, or obstruct the ability of a witness to attend, testify, or provide information in or for a present or future official proceeding. And these calls, at the very least, evidence an attempt to do just that, to impede this specific witness's ability to come to court. Given that I believe that these calls establish that the defendant has used the phone system to commit another felony for the purpose of impeding with this case and attacking the integrity of these proceedings, I can't think of a stronger reason that there could be to revoke someone's phone privileges. And so that being the case, I'm asking the court to do just that.
Mr. Johnson.
Judge, I would indicate to the court that clearly there's some comments in here that could be construed in a manner that my client did reach out to a third party to make contact with the family or to get someone to speak with the party that could testify or is involved in the matter. However, what is unequivocally clear and what is absent from this is that there are no threats of harm. There is no offer of payment or consideration for or request for someone not to show up in court. There is no threat of violence or use of force against a witness. His desire to have someone not keep putting his name into this case could be construed in a number of ways, but I don't think it rises to the level of making it unequivocally clear without just mere implication that my client did want someone to make contact. What I do think is remarkable is that he does say that he does not want to incriminate himself as though he is threatening the witness. So what I'm suggesting to the court, Judge, is that my client, this is a very, very serious situation. As this court knows, defendants in situations like this, when they first locked up, they do get desperate. They get a little frantic. He hadn't received his discovery yet. I would suggest to the court that he made an error by even suggesting or even thinking that he could reach out and have someone say, hey, quit tossing my name out around this stuff. Quit saying this. And his comments about not wanting to go to trial, I don't think that necessarily implies he doesn't want somebody to show up. That takes a quantum leap to make that conclusion. But what it can be construed in a number of ways. But what I think he meant is he does not want to end up having to go to trial on this if in fact he's innocent. So, Judge, I think a strong, stiff admonition from the court, myself, is sufficient. He can still be monitored. If in fact there is an issue later, we can deal with it. But I can attest to this court that as right now he's told me that I will be representing him, and if I'm representing him, Judge, I can attest to this court, you do not have to worry about anything like this occurring again. I would ask the court to admonish him, and let's move forward.
Mr. Jones? Mr. Jones? Can you state your name again, sir?
Simone Jones.
Okay, Mr. Jones, I don't take this lightly when the prosecutor is asking to revoke phone privileges. And which is the exact reason why I wanted to either hear the phone recordings or be sent this summary of same, which your attorney has been privy to. The language that is summarized in this email that I received, if you take perhaps one item and look at it and isolate it, I can see that Mr. Johnson's argument makes sense. But the totality of not only the circumstances and the allegations for which you face, coupled with the entirety of these several calls, is what the court is considering. And there absolutely is reason for the prosecution to be concerned. So while I certainly can understand facing these most serious allegations, your temptation to want to speak on this matter, it is completely unacceptable. There can be no indicia, no hint of any impropriety or any manner in which you might be attempting to threaten or have someone else act in a way that would make one feel threatened or do any harm or any inference that would make one think that you are trying to prevent them from testifying. And I'm not sure what you had on your mind when you thought that that was acceptable. But if there is a motion that's being made, which there is, to revoke your phone privileges, I absolutely believe that there is a basis that has been provided by the prosecution in an attempt to maintain the integrity of this judicial process. With that, I am going to grant that motion. I do need you, Mr. Elsey, to prepare a proposed order in that regard that you can forward not only to myself, but to Mr. Johnson, so he can have that for his file. If you could forward it to Mr. Sanders as you did the summary of the phone calls, and I will sign that straight away. And absolutely, I would take the wise counsel of your attorney, Mr. Johnson, Mr. Jones, and moving forward with this matter. Is there anything further that we need to deal with?
Nothing further from the defense, Your Honor.
Nothing further from the people, Your Honor.
We have an exam date already situated, which is just as a confirmation here, September 9th at 1:30. I have in the interim signed the protective order. Mr. Sanders, if he hasn't had a chance to forward it back, he may not have, because I think it's been sitting here with me. He will do so shortly, and we'll look for that proposed order, Mr. Elsey, regarding the phone privileges.
I will send that shortly, Your Honor. Thank you.
Thank you.
Thank you.
Thank you, Your Honor. Have a wonderful day.
You too, Deputy. Yes, sir.
We have another testimony here.
Okay, but do we have anything else?
No, that's it.
Okay.
Did Ms. Cross sign right now?
Yes. Okay, you can call the tether violator.
That's it.
Ms. Kraus?
Yes, Judge.
Good morning again, or good afternoon. Did you say, or is your client zooming in?
Yes, he is on the iPhone, Judge. Mr. Havis, can you turn on your video and unmute yourself? It's the little video camera.
It's we can't really hear that clear. Sounds like he's having technical difficulties.
Judge, I believe he's at or near a hospital with his son, he told me.
Okay. Can I have the Hagus files, Mr. All right, this is a recall of People versus, do we at least have audio of him or no?
Oh, shoot.
Let's see if he tries to get back in.
There we go. Mr. Havis, can you hear us? Unmute yourself.
Oh, yes, I can hear.
Okay. Okay. This is a recall of People versus Troy Havis. We have case number 200577787 and 200572339. Appearances, please.
Good morning or afternoon, Your Honor. Bryn Bailey on behalf of the people, P84009.
And good afternoon, Your Honor. Sarah Kraus, P81830, appearing on behalf of Troy Havis for both matters. Mr. Havis is here by Zoom. Mr. Havis, can you state your name, please?
One more time.
Troy Martell. Troy Martell.
All we got was Troy Martell. Last name?
Havis.
Thank you. All right, today was the date and time set for an examination, and you were not here, so we were going to, actually on the record, habeas was granted, which means there's an open warrant for your arrest. However, as I told your attorney, if you were able to at least appear on Zoom, then we could pick up where we would have left off had you been present. So were there any witnesses that were present?
Your Honor, the people did not have any witnesses present. They were subpoenaed, and they were given reminders of today's date, Your Honor, and did not appear.
Is there a motion?
Yes, Your Honor, I would move to dismiss both cases at this time.
Okay, given the fact that the prosecution was unable to proceed, the matters are both files that were called onto the record are to be dismissed. Oh, he just left off, but I'm assuming you'll be in contact with him, Ms. Krause?
Yes, I will, Judge.
Both, and there he's trying to come back in. Both matters will be dismissed without prejudice. Please make sure that he understands that it is possible that they can be reissued. But as for now, they are dismissed without prejudice. Does he have on a GPS tether that needs to be removed?
No, Your Honor.
Okay. Is there anything further?
Nothing further from the people.
No, Your Honor, thank you.
I do have one other thing to ask. Ms. Krause, do I have permission to sign your name to the order of dismissal as the moving party?
Absolutely.
And as a matter of housekeeping, the habeas that was put on the record is set aside.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
You're welcome. Take care. Okay, and so this tether violator, we're trying to, is that your case, Ms. Van?
I believe so, Your Honor. I do show that I believe so.
Okay. We're trying to see what's going on with court-appointed counsel in that matter. Absolutely. Deputy,
Hold on one second. 360-233.
is there a deputy near you? Hold on, don't hang up with me yet. Deputy,
Hold on for a second.
Yes.
are we able to have him at 1:30? Because if not, we'll need to bump him to tomorrow.
We can do him at 1:30. Hold on, sir.
Okay, great.
Yes, we can look back in at 1:30.
Okay, great. A court-appointed attorney is logging in at 1:30, Mr. O'Donnell, and we'll connect the two of them.
All right, thank you, Your Honor.
Thank you, take care.
Mhm.
Ms. Bailey? We have Ted Riley, correct?
Right.
Do see Mr. O'Donnell, so you can go.
Okay. Calling parties on Marquise Alexander. Calling case number 21-59681, People versus Marquise Jarrell Alexander. Defendant is charged with 1 count, unarmed robbery. Defendant is here today for a tether violation.
Thank you, sir. Appearances, please. Mr. O'Donnell is here. Who's the prosecutor? Ms. Bailey? He's connecting to audio. Ms. Bailey, are you here? Oh, you know what? I think they went to a breakup. Yeah, can you give Mr. O'Donnell a telephone call and tell him that we are on the record? And that I put him in.
Prosecutor doing?
I'm sorry?
Is there a prosecutor on there?
Yep, I'm there. Okay, so the reason why.
Okay, hold on. What
Yes, Your Honor. Sorry. Bryn Bailey, on behalf of the people.
Is that APA Bailey? Hi, Miss Bailey. This is Jim O'Donnell. I guess I better not talk. Hi, Kim Miles.
Mr. O'Donnell,
Yes.
we're gonna call your case shortly, okay? Can you give us a moment?
Yes.
Please proceed.
Thank you. So her testimony is important because if the complainant, and we have to proceed on, the evidence that's on record, which was her direct testimony. If the complainant was shooting back, then anytime he's contacted by the police or the attorney, he should also be made aware of his right to an attorney because he is also in danger of compelled self-incrimination unless he makes a knowing and voluntary waiver of those rights. Mr. Smith was not given those rights. I will say that this was a complaining witness that appeared not to have wanted to press charges. The police went to I'm going to try to stay away from putting facts on the record I know that are not on the record, so let me rephrase this. What do you think about this? Mr. Smith was not in voluntary contact with the police and the prosecutors, even though he had the potential to also be charged with a crime, because he was also unlawfully shooting at that time, or so the allegations go from the testimony on record. He should have been advised to his rights. We don't have any evidence of that or a waiver of his rights. He was brought in on a witness detainer and treated as a normal witness and questioned under the hostile witness rule without it going on record that his rights were read to him. Now, according to the bond argument, not the last hearing, the hearing before, this particular complaining witness, who's also in jeopardy of being charged with the same crime Mr. Dates is standing here before you accused of, was shot. He's in the hospital. He's now a potential victim in a separate crime, a separate complainant. And I just want to put that out there, that that's a fact in this case. The next hearing that we had in this honorable court, in that hearing where it was revealed that Mr. Smith and his family were shot, it was stated that Mr. Dates was suspected. And the thing is, Judge, Mr. Dates is in county jail. If he's suspected of doing any such thing, there would be jail records ordered immediately. They would look at anyone that visited him. COVID's a little bit different. They would go through his jail calls. Upon information and belief somebody else was arrested for that crime, the next time we were in front of this honorable court on my motion, this was not mentioned at all, that he was suspected of a murder. Yeah, and it is important to note that once Mr. Smith testified that he actually was the driver involved in the shooting, then if you take that in hand with Ms. Hudgens' testimony, he did put himself in jeopardy. He did incriminate himself without a voluntary waiver, which I believe is behind the prosecutor's request to strike his testimony from this record and not to call him an examination. They've also averred that they're not calling the civilian Isis Terrell examination. There is an open CPS investigation into Isis Terrell and the child that she shares with Mr. Date. For at least a few months now, they've been in probate court over custody of his baby and her baby, their youngest child. Because there's an open CPS investigation, law enforcement has to be very careful about how to question her. And in order to provide a very effective defense for Mr. Dates, I would have to bring this up as it creates some sort of bias, some sort of motive in this identification, even in a one-person photo lineup. And I will say, if I attach that one-person photo lineup had writing on it that said, is this Levon Dates? And Ms. Terrell said yes, and that was the scope of it, not is he in the video? Is he the shooter? Did he do this? The fact that I would have to incriminate Ms. Terrell, which I don't know at what point the office, the Wayne County Prosecutor's Office, or APAs became aware of it. Perhaps it was on filing of this motion. I don't know, it could have been. At that point, Ms. Terrell should have also been assigned an attorney because she puts herself in jeopardy with that CPS investigation. She was not, and it's no longer their intention to call her. So we've gone through the bench warrant issues on the record pretty specifically. When I did file this motion, I did receive a number of items from the prosecutor's office. So this is the amended motion. I believe I filed the other motion 2 hearings ago. This one was filed June 21st. June 17th is when I filed the first one. On June 17th, I did receive a discovery package, but it was missing any report. So all of the officers in the videos, I don't know who they are. There weren't any dates on it. There wasn't any type of location or place. A number of these videos were totally foreshortened. A couple of them were just empty. I'm sorry. This is unusual, like I said. I haven't seen this before. There were 2 irrelevant vehicles doing nothing other than getting gasoline. I believe this was an effort to waste defense's time. I truly do. This had little to no evidentiary value except for 2 unknown officers. This is the April 30th DDC interrogation. At the DDC, rousing Mr. Days from consciousness and interviewing him. I don't have any of the writings. It shows them writing. I don't have any writings or anything. Mr. Dates, clearly he had just been released from the hospital. The other video clip, it starts with an officer coming onto the scene. He's in his car and he's walking across, I don't know, a little bit of grass, maybe a street and a sidewalk, and he comes upon a scene. There's at least six unknown officers standing on the grass with Mr. Dates. He's either unconscious or semi-conscious. You can hear one officer say, "You shouldn't have run," and that's it. I have no location. I have no writings of that event. I didn't have the names of any of the officers. And Miss APA Morales' response, I believe she referenced that these are from the receiving and concealing auto theft case that Mr. Dates has. But the fact is, that's when he was arrested and picked up on the A1. And if they were from the receiving and concealing case, Your Honor, which is what's being represented, they should have been turned over to defense even earlier than these, since that warrant issued much earlier than this warrant issued. There was no reason that defense should have had to have waited that long, especially since the very first hearing, I referenced to the prosecutor in charge of that case that he had a case that there was a warrant out for Mr. Dates. I would like to put on the record that Mr. Dates, has continued to have difficulty receiving health care while inside Wayne County. His shoulder was dislocated in December. And then in this arrest, Mr. Dates was unconscious and semi-conscious for parts of it. There was also a car crash. And by the way, when that scene opens up, he's in the middle of somebody's lawn. He's not in a car. And I don't see any other civilians around him in the frame. That he was taken, his stitches were allowed to grow over and fester. He was taken for those, but his shoulder was re-injured. He was not taken to the hospital for the shoulder re-injury. He was on pain med. It was just like Motrin 800s, Tylenol 800s, nothing like Oxycontin, nothing like that. He's no longer on the pain meds. I'm gonna make some contact. We're hopeful that he can be put back on the pain meds, and there was imaging taken of his shoulders. He was supposed to go back and have a consultation so they can tell him and read it to him, give him a diagnosis or a plan of treatment. We're hoping for that. So the end of my motion, I will also make, or perhaps if I'll wait until, if you want the exam to continue and make another motion at the end, but while I'm thinking of it, that would go into a motion I would make to reduce Mr. Dates' bond. A lot of the facts would. Give me just one moment, please. So there was also a statement that Mr. Dates was made during the bond argument by APA Major. That I failed to write down, but that's on the record, that Mr. Dates was fleeing and eluding during the arrest. Well, this works both ways. If this isn't true, then it's another incorrect, inaccurate, untrue statement during bond argument. If it is true, then Mr. Dates was not charged with this. Defense did not have enough notice to properly defend him, and there was not any evidence in the form of writings nor videos provided to underlie the probable cause for that charge. I would also just like to, I believe that may thoroughly represent what is in this motion. Let me just check. I believe that sending the discovery in this manner was a waste of time. I believe that the warrants sitting there was a waste of defense time. A Mr. Dates case required an investigator, especially when there's evidence we don't have and cannot seem to be able to obtain under the law. To get her resources and my resources were spent trying to obtain a large number of them, trying to get these warrants arranged so that Mr. Dates would not be stuck incarcerated if these charges were dismissed without the rule of law, not receiving health care. And our efforts were also wasted just by trying to figure out how he was arrested and what happened in trying to put together the partial bits of information I could get from my client, who at some point lost consciousness, right? And the missing evidence. There was a lot of effort and time wasted when our role in this legal system should really be advocacy, gathering evidence and proofs for a good faith effort to defend him, to mitigate him, to find exculpatory evidence, and to uphold his rights. I thank you for your time and attention to this matter. I know that it's very unusual. I thank you very much for allowing me to make my record. And we hope that you will grant a donation.
Madam Prosecutor.
Thank you, Your Honor. First, the people would like to state that there is motion dismissed. We would request that to be denied. There is I'm going to go point by point from what the defense counsel has said. Your Honor, let us start with the fact that Mr. Dates was not arrested because of this matter. There was a totally different issue, and this hadn't even gotten through the process yet. He was arrested because there was another allegation of a crime and in pursuit, and then another accident, part of that case, and then another accident, I believe was a civilian accident, and he left the scene of that crime. And that's why, as Ms. Counsel stated, that he's not in a car and there's no other civilians around, because he left the scene of a civilian accident. And that is when they tracked him down. And that is when they realized who he was and why, and that they were going to detain him because of that. On a suspicion of other cases. There was an interrogation video that was done. I found out much later. Again, that had nothing to do. This case wasn't even mentioned in that interrogation video, which is why it wasn't shared with me or given to me as part of discovery in this case. So Your Honor, like when you're familiar with evidence.com, as far as that's where we keep our discovery, each incident police report is tied to discovery. And everything for that incident is put in that case. Because of the other issues having nothing to do with that case, it was not tied to my case. I did, out of respect for this court, because you had requested me to, went on a fact-finding information and tried to find the other information and did supply that once I was able to take a look at it, because, you know, it is our policy that it must be reviewed before it is shared. So everything that I have done has been in good faith effort to provide the defense with as much discovery as possible at this stage. The bond argument, there was some mistaken facts, but they're not untrue. They were just mistaken. It wasn't green light, it was CCTV. That's just a error at best, a misstatement of fact, not a difference, not a misconduct. And we bring it to the court's attention that this was titled prosecutorial misconduct. There is nothing in this motion that rises to the level of prosecutorial misconduct. Prosecutorial misconduct has been defined in several different cases as was the defendant deprived of a fair trial. That has not happened throughout this process. The people would state that there has been no prosecutorial misconduct. The defense has went on to say that there was a bad lineup. Your Honor, when two parties know each other to the extent that they have had a trial together, and as defense has stated, are even in court proceedings about that trial, there isn't a lineup necessary. Familiar and known people can make an identification. Is this him? Yes. Because they are known persons to one another. This is not a case where there was a witnesses that didn't know each other. This was a case of somebody who spent significant time with the defendant. And familiarity does not require a photo ID when they're that familiar with each other. As to the witnesses, both Andre and Ramona Hutchins, it was their duty to claim any kind of right to Fifth Amendment protections or anything like that. That is not our duty to do so. They were not being charged by our office, and that's why we didn't have anything there. That is their duty to make that claim. As for witness tampering or anything to that effect, if there are texts about that, I certainly haven't seen them and it hasn't been shared with me. So I can't testify or comment on something a witness has told somebody else entirely outside of these proceedings. It wasn't shared with the prosecution. As for Mr. Smith, Andre Smith, he was called because he was the complaining witness and a party to the action. He wasn't being forthcoming, so we did request a witness detainer, which Your Honor did sign and have him brought in. Throughout that testimony, he still was not cooperating with the court or didn't say much to be of cooperation to the court, sorry. Didn't say a lot, didn't provide a lot of information other than he was the driver involved at that time. As to the wasting the defendant's time, at no point did the prosecutor's office attempt to waste the defense's time in any sort of manner that would not be considered in good faith. There is a lot of detail. There's a lot of video. There's a lot of paperwork that takes a lot to review, and these aren't our only cases. As you are well aware, Your Honor, I have been in front of you 2 days this week already. I have another one tomorrow. We have plenty of cases, all of them entailing this kind of information, all of them entailing review of a lot of body camera footage, video footage, paperwork, and paper discovery. Everything was turned over as soon as I was able to locate it and review it before, even though it had nothing to do with this case. Another statement from the defense said that The fleeing and looting referenced by Ms. Najjar was incorrect, that it wasn't true. But the officers at the time were responding to a car crash, and he was seen leaving that car crash, leaving the scene of the crime, leaving the scene of an accident, and he was chased after that. And while I feel for Mr. Gates' issues that he is having with his health care, that again is not within the purview of the prosecutor's office. That is the Wayne County Jail. And this office can't tell them how to do their job other than the court's recommendation to have it medically flagged. Your Honor, I believe the prosecution hasn't even had a chance to put forth its case yet. We have not been able to get through to the in-part exams through the end. At this time, I believe the people would ask that the motion be denied and claims of prosecutorial misconduct be denied as well. Thank you, Your Honor.
Thank you. Okay, having had an opportunity to not only read the first amended motion made by the defense, as well as read the people's response, and now hear the oral argument and oral response from the prosecution, the motion is noted, but the motion is denied to dismiss. And certainly the issues that you've raised, Madam Defense, can be preserved and presented at a later time if it is necessary to do so, but the motion at this juncture is denied. It is time for the continuation of the examination. Is the prosecution prepared to proceed?
Yes, Your Honor, the prosecution is prepared to proceed.
Sequestration has already been ordered in this matter. It's going to continue. And I am going to, before we jump into this, we're going to call a quick matter, but the Zoom gallery is already restricted and will be even more so restricted after we call this next case. And if there's anyone live feed on YouTube that is either a witness or a potential witness, should stop from watching to maintain the integrity of this proceeding here today. I guess I should also address that for the sake of transparency, that the courtroom is already restricted to spectators with their inability to enter the courtroom due to the COVID restrictions that are still in place. We are going to pause just, however, for one moment so that we can address one quick matter. People versus Mr. O'Donnell, what is your client's name?
Marquise Alexander.
Thank you. This is a recall of Marquise Alexander on 059681. It's already been formally called, so I'm not going to formally call it again. Can I have appearances, please?
Good morning, Your Honor. Bryn Bailey on behalf of the people, P84009.
Good afternoon, Your Honor. James O'Donnell, Neighborhood Defender Services, P42585, on behalf of Mr. Marquise Alexander. And I apologize for interrupting earlier. I did not know the court was in session.
That's okay. Could you please state your name, Mr. Alexander?
Marquise Jarrell Alexander.
Thank you. So, Mr. O'Donnell, I'm assuming you've had an opportunity to review the tether violation report?
I did.
What's your posture on it?
Judge, I'm going to ask the court, or going to tell the court, that my client has been arrested on a new charge. However, when he went before the arraignment judge, the judge set a personal bond, $2,500 personal bond with house arrest. He, at the time—
Wait, Mr. O'Donnell,
yes?
You're also kind of dipped, and Madam Court Reporter, I could tell, didn't hear. The bond was $25,000 personal, correct?
The way my client tells me, it was $2,500 personal, but yeah, whatever the court has before it is the correct amount.
I'm showing 25,000.
Yeah, 25,000.
Right. Okay, I apologize. In any event, he was not out of place or in a restricted area. he was ordered by his tether not to go into Hamtramck. He did not go into Hamtramck. He was at a gas station. He says that the independent witness in the new case, the robbery is an armed case, is lying, and that will be shown when he goes to court. He's asking the court to continue the same probation that his new case has, which is $25,000 personal bond.
Okay, so is the allegation of the new incident an incident that was picked up allegedly after he was placed on bond for the instant matter?
Yes.
Yes, Your Honor, not even a month later.
Then that's a problem, Mr. O'Donnell.
Your Honor, can I speak?
Hold on 1 second. Mr. O'Donnell, so I'm clearly not going to reinstate the $25,000 personal bond when he picked up and has been charged in a matter that happened subsequent to him being placed on bond for the instant offense. Mr. O'Donnell, do you want your client to speak?
Not just yet, Your Honor. Can the court tell me what his bond is on the most recent case?
So, Your Honor, I think I might have a little bit more information. So this armed robbery, which is the new case, is the $25,000 personal. On the case with which he was on tether, it was $2,500, 10% with GPS tether, it looks like, and it's a domestic.
Okay, now I'm confused. I have before me Marquise Alexander, 2105961. It's a charge of robbery unarmed. The pretrial release form indicates $25,000 personal bond with a GPS tether and house arrest. That's dated July 21st, 2021. Am I looking at the wrong file?
No, Your Honor, that is the new chart.
So why don't
yes,
I have
Judge. Judge, I don't think you're looking at the tether violation file. I think you're looking at the new case file.
I need the file that corresponds with this, if you can find it. Okay, please proceed. What would you like me to do, prosecutor?
Your Honor, I would tend to believe that reinstating a bond with GPS tether after picking up a new case, especially a personal bond or a $2,500 10% bond, might be too low. I'd ask that the court increase the bond to a 10% of the $25,000 with GPS tether house arrest.
Just to be clear, the matter for which he is before the court, not the new one, the matter for which he was placed on tether, which is, I'm being handed right now, 2004547. He is on a bond of what? Wait, I'm sorry. You know what? Hold on. I'm going to ask, Mr. Clerk is going to call Mr. Bailey, Mr. O'Donnell and Ms. Bailey. He's going to call you separately. I have to pick up with this examination. It sounds like I'm being handed information. I'm not even sure why he's being violated now. So once everybody is on the same page, just let me know and I'm going to call it. Mr. Sanders has some new information, okay?
Yes,
he's going to call you. Calling you right now. We're back on the record in the matter of People versus States. Next witness, please.
Thank you, and people would call Detective Eric Carthan.
Is somebody going to get him? Sure. Oh, okay. Please state your full name, sir, and spell your first and last name.
Oh, and Your Honor, I'm sorry, a housekeeping matter before I proceed with that. At this time, the people would move to strike the testimony of Andre Smith. He has been subpoenaed for every hearing that we've had since. He has yet to appear, other than doing another witness detainer and having him brought back in front of the court. There has not been a chance for defense to cross-examine, and we can't proceed with that testimony.
Okay, so the testimony that
I believe was heard on June 10th or July 10th, June 10th.
testimony that began on June 9th, actually.
June 9th, okay.
That testimony of Andre Smith in particular is going to be stricken from the record.
For the record, I object. We'll make an offer of proof.
Okay, I didn't realize there was an objection. What's the objection?
The objection is, it's not defense's fault that we didn't have an opportunity to cross-examine. Oh, yes, I will, sorry. It's not a defense's fault we didn't have an opportunity to cross-examine Mr. Smith. His testimony materially stated that he could not identify Mr. Dates as the shooter.
The testimony will remain. Next witness. Please state your full name and spell your first and last name for Madam Court Reporter.
Eric Carthan, E-R-I-C, last name Carthan, C-A-R-T-H-A-N.
Thank you. Please raise your right hand. Do you solemnly swear or affirm testimony you're going to provide here today is the truth, the whole truth, and nothing but the truth?
Yes.
Thank you, sir. You can come up here. This cap gate will swing open towards you. Once he's settled in the witness chair, you may proceed, Madam Prosecutor.
Thank you, Your Honor. Sir, can you state your name for the record, please?
I'm Eric Carthan.
And sir, are you employed?
Yes, I am.
How are you employed?
Detroit Police Department.
And were you in that capacity on the date of March 12th, 2021?
Yes, I was.
And were you involved in an incident with Voluntarian States?
Yes.
And how were you involved, sir?
I was recalled to a shooting scene.
Okay. And where was that shooting scene located?
I was in Rosa Parks at a gas station.
And that's in the city of Detroit, County of Wayne, state of Michigan?
Yes.
And what did you do upon getting there, sir?
What I did upon getting there?
Yes.
I went there, canvassed the area at the gas station, took statements from the witnesses, reviewed the store video.
You said there was store video?
Yes.
Your Honor, at this time, I'd like to play that video.
Has defense counsel had an opportunity to review the video?
I have.
Do you need to share screen?
Yeah, you know, just 1 second so I can get it to stream without disconnecting your.
I don't see that you've entered in, but.
Yeah, I have to set up my personal hotspot first, sorry, for my computer to talk to the network.
Just a second.
Sir?
Yes.
Let's get rid of the feedback.
I think you need to, can you mute your microphone?
I thought I did, and I actually turned it off a second ago. Let me try that again. Speak back from the second. My microphone is off, so it must be the other court microphones.
Well, I can tell you that oftentimes when videos, I'm not tech savvy, you may need to take it to another room in the hallway.
Not a problem, Your Honor. How is that, Your Honor?
I think that's better.
Okay. Sir, is this the video in question?
Yes.
And does this fairly and accurately depict the video that you reviewed that night?
Yes.
Your Honor, please play the video in full.
If you could maybe move it a little further away, we still hear the crescendo, but go ahead.
Yeah, I need to, just give me a second to turn off the volume on my laptop. I think that'll end this problem.
Okay.
Okay, Your Honor.
Much better.
What is it, the people would like to play this video in its full and be people's people's evidence number 2. Sorry, number 1, I'm sorry. I think it's number 1. I don't think we've had any evidence thus far.
And what, are you seeking to admit that?
I was seeking to admit this.
Counsel?
No objection, Your Honor.
Will be admitted as people's 1.
At this time, I'd like to play the video in full. Thank you, Your Honor. And sir, was there a person in that video that you've spoken to?
Yes.
And who was that person?
Andre Smith.
And which vehicle did he just get into?
That dark colored Envoy.
Okay. And sir, did another vehicle approach at that point?
Yes.
And what color was that vehicle?
It's like a tan cream minivan.
Okay, and was the person driving that vehicle identified?
Yes.
Who was that person?
Mr. Davis.
Objection. No foundation for identification.
Objection sustained.
And sir, this incident that happened, what happened after the black car passed in front of the tan one?
He proceeded to walk past the vehicle, then he turned around and started firing shots into the back of the vehicle.
Okay. And Your Honor, I'd like to replay that short section. Sir, is there a person by the black envoy?
Yes.
And were you able to identify that person?
Was later to identify him as Mr. Davis.
Objection. No foundation for how he was able to.
Objection
identify.
sustained again with regards to the same question.
Understood, Your Honor. And sir, so that video, I'm sorry, I'm gonna shut that video off at this time, Your Honor.
Okay.
And sir, there was a person involved, the envoy. Were you able to talk to that person?
Yes.
And you said, I'm sorry, who was he identified as?
Andre Smith.
And did he state that he was involved in, did he tell you information?
He basically gave a little brief information. He wasn't that comfortable, but he gave a little bit.
Okay. So you reviewed that video. What is the next thing you did when you were on the scene?
At that, at the gas station?
Yes.
Reviewed the video, request ABER to come out to extract the video. And then we went to the hospital.
Okay, and were you at the hospital? Did you make any observations?
Yes.
What did you observe?
Observed Mr. Andre Smith with a gunshot wound to his right shoulder.
Okay, and was there anything else you observed while you were there?
Pretty much just uncooperative. Just gave brief statements.
And if I asked you to refresh your recollection, would that seeing the investigative report help?
Well, before I walked in, I did see his vehicle in the parking lot.
Thank you. And what was that vehicle?
The Envoy, dark colored GMC.
And who was it? The GMC?
Yes.
Envoy? Okay.
Yeah.
And who is that registered to?
I don't recall at this time. I think it was registered to him though.
You do believe it was registered to him? And if I showed you your report, would that
Yes.
help you?
Okay, while you review that, and please make sure you share it with Ms. Sadi, just so she knows exactly what you're approaching with. Is the deputy at Wayne County? Deputy? Hi, deputy? Hello?
Your Honor, are you talking about Wayne County?
Yes, yeah, thank you. I wanted to know, can I trouble you to call my clerk right now at 965-2282?
You said 965?
965-2282.
2282. 2282.
Thank you.
One moment. No problem.
Okay, please proceed.
Thank you. Sir, did that refresh your recollection, or do you still need time?
Yes. Yes.
I'm gonna come and take that from you real quick. And so was there a registration run?
Say it again?
Was the registration on the vehicle run?
Yes, it was.
And what were you told about that registration? I'm sorry, what did you find in your investigation about that registration?
I belong to the victim.
Okay. And you went next to the victim?
Yes.
And I'm sorry, what did you say about your observations there?
Observation, the rear window was shattered out of the vehicle.
Okay. And when you went to the victim, what were your observations there?
He had a through and through gunshot wound to his right shoulder.
And thank you. And sir, you said that there was a time when you came to find out who the person in the video was.
Yes.
And how was that determined?
We got a phone call from which one, the male or female? You want?
Whichever one is first in your list, sir.
Okay. The female, her mother called, Ramona. Her mother called the station and said that's her daughter.
And when you say Ramona,
yes.
There was testimony heard from her earlier. Is that the same person?
Yes.
Continue.
Then later on, we got a phone call from Mr. Date's child's mother. Stating she recognized him because they went to school together, elementary school together, and then also have a child together.
Okay. And was information provided?
Yes.
Any further information provided?
Yeah, I did a single photo lineup.
And you said that they have a child?
Yes.
They have a child together?
Yes.
And she identified him from the picture?
Yes.
And that picture versus the video, I'm sorry, let me back up. Ms. Terrell, how did Ms. Terrell say she knew him from? How did she see anything about him?
I ran the incident through on the news.
Okay, so it was on the news?
It was on the news, yes.
This case was on the news, okay. And she called in on her own?
Social media, yes.
Social media, so it was on social media and she called in on her own?
Yes.
Thank you. And she identified that person?
Yes.
And who did she identify him as?
States.
So Levon?
Levon Dates.
Yes. Okay. No further questions, Your Honor. Cross-examination.
So the shooting was March 12th, correct?
Correct.
And when did you arrest Mr. Dates?
When I got a phone call that he was involved in a traffic crash. That's probably about a few months later.
Okay, and did you go to the scene?
No.
Okay, so who arrested Mr. Dates? Are you aware?
Where officers in 10th precinct, I don't remember their names, who arrested him.
Which precinct are you in?
10th precinct.
Okay, you don't recall who told you, we got him, we got the shooter?
Well, I believe somebody did say, hey, I believe the guy that's involved in the traffic crash look like the guy he was looking for.
Okay, so it sounds like you put a lot of work into investigating this case. Let me start with social media. Was this the video you ran on social media?
Yes, some of it. I think there's more to it, but yes, that's part of it.
Okay, that's a partial video.
It's got different camera angles.
Okay, so how many videos of this shooting are there?
Maybe how many cameras they have. I'm not really sure. I really don't recall.
I mean, you were there. If I gave you your report, would that refresh your memory, or you might have it up there already?
Well, I don't recall how many cameras. Actually, I really just downloaded the video.
How many videos did you pull from the cameras?
I already do like 3 different angles.
So how many videos are in the possession of the police department of the shooting?
I don't recall right now.
You pulled 3, right?
Yes.
So what do you do?
I'm saying there could be more, but I don't know these 3.
There could be more?
Yeah, we have some inside video cameras, outside cameras.
But did anybody go into the store during this? Go inside the store during the shooting or after the shooting?
You talking as far as officers?
No, I'm talking about as far as the accused and the complainant. The people involved in the whole reason you're involved in this case.
He was in the store earlier that day.
Who?
Mr. Dates.
Mr. Dates was in the store earlier that day. That's not in your report, is it?
No.
And there is no video that was turned over to defense showing Mr. Dates in the store earlier that day, is there?
I don't know. It should be.
There should have been a video turned over to defense showing Mr. Dates in the liquor store earlier.
It was downloaded evidence.com. It was downloaded evidence.com.
And then when you do that, what do you do with that?
Not after that.
When was this given to defense or downloaded to evidence.com? Approximately when?
It's the time that we did the report, so within a day or two.
Within a day or two. When did you do your report?
If that was the 12th, it had to be It got signed to about the next day, so 12, 13, 14.
So you wrote a pretty extensive report in this matter, correct?
Yes,
And you didn't mention at all that Mr. Dates was in that store earlier today, did you?
probably not.
And you didn't mention at all that there was another video that existed of Mr. Dates at the scene of the crime earlier that day, did you?
It's still in the video.
I'm sorry?
All the video was loaded together, everything.
Okay, so if I'm missing video,
Has nothing to do with me.
it has nothing to do with you. So who does the video go to once you load it?
It goes to evidence.com.
Okay, now do you load it or is there a special technical person?
I can load it.
What happened here, please?
It was downloaded from Aver, and then it got uploaded to evidence.com.
By whom?
I don't remember the technician's name. I think it was
Sergeant Wiener?
Amarine.
Cameron? Can you spell that for me,
I don't know.
please?
I don't know how to spell it. I think it's Amarine.
Amarine. He was at the scene as well, along with Officer McPhee, is that correct?
Yes, he was recalled to download video.
And, was he equipped with a body camera?
Aver don't be equipped with a body camera. They don't.
What'd you say?
I said Aver, computer people, they don't be equipped with body cameras. They don't wear body cameras.
So, was there ever a different OIC on this case?
You can work in teams, but I don't think I was solo on that one.
Okay, and does the name James Weinsick ring a bell?
Winsett?
Yes.
Sergeant Winsett? Yes.
Okay, is there any reason why he would be requesting these videos instead of you?
He was the op supervisor that day.
So he also knows that there are more videos that exist, including one of Mr. Dates that was never mentioned. He should also know that because he's familiar with the video evidence, correct?
I'm not sure.
So you don't know if he's actually seen them, he just requested them?
No, I'm sure he watched. They was there before we got there. They got there before we did. And we were recalled. So I'm sure they watched the video.
Is he an active investigator on this case?
Nope.
Why would he request them instead of you?
He's a supervisor. Supervisor requests the video. If they see the video as something that fits the crime, they will request it. We don't have to do it. They'll beat us to it.
So he downloaded it, not you?
No, he didn't download it. He requested it. He put the request in.
I see. Why would his, so is he your direct supervisor?
No, he's special ops supervisor.
Okay, so why is special ops involved?
They made the run
What run?
to the gas station.
Okay, so what police officers made that run? We have, I believe, Sergeant McPhee, and I have his body camera. And then we have Amarick, who pulled the video. He's Aver, special tech, right?
Correct.
Who else was there?
Whoever McBee partner was that night.
Whatever, what?
McBee partner was that night. It's in the report. It should be in the report.
Now, did you also download that video, their body cameras?
All the video was downloaded. All the video.
Okay, so McBee's partner was the one that cordoned off the gas station parking lot and did a sweep for, I don't know, bullets, whatever you look for after a shooting, right? Blood.
Okay, the officers should have did the cameras. They should have did the cameras.
I'm sorry, I didn't.
I said officers should have did the cameras so they hear me.
Yes.
Responding.
So if I only have about 2 or 3 minutes of this sweep, do you know what happened to the rest of the video? Do other videos exist of them sweeping the lot?
No, that would be it.
Okay, so no gun was recovered.
No gun was recovered.
Any shell casings recovered?
Yes.
Okay, how many?
I don't recall. It's in the report. I have to look at my report.
Go right ahead, please.
multiple brass casings.
Do you know what, I don't know the term, make and model of gun, I guess they're from? Millimeters? Are they all, I mean, do they all appear to be from the same firearm?
I'll have the, get the, tech support.
Thank you. Thank you.
I'm sorry, what was your?
I said we'll have to look at the, evidence tech, they recovered the process of the scene, we have to look at their report.
Are you looking for it, or are you waiting for another question?
I was leaving up.
Oh, okay.
Oh, I
Another question?
misunderstood you, thank you,
Oh.
yes. Okay, so you're not sure, okay,
Yeah.
that's okay. I'm gonna go someplace else now, so I'm gonna go back to these videos. I believe you testified that you put a video clip on social media, correct?
Yes, I gave it to the social media, unit, and they give it to the news, and they decide which one they want to use.
So, just for clarity's sake, the social media unit is within the Detroit Police
Yes,
Department, right?
Yes.
And do you guys have like a regular news page, something in the D where you post?
Crime in the D?
Yes.
I think they have it, but I'm not sure. I think they use that. I think they use Fox 2, Channel 12, or whatever the news is, I believe. Whatever social media that they deal with. I don't know what exactly how they deal with it.
Do you know which one this video, I'm sorry, was this the video released on social media?
Some of it was.
Okay, were there any other videos released on social media?
All I know is that the videos was released with the pictures were released, I believe.
What pictures exist?
Of the offender and the Miss Hudgens standing at the car together.
Standing at the car together, so, who pulled that picture from the video?
Aver decided which picture, probably Crime Intel, or Aver decided which one. I think Crime Intel pulled that picture, Crime Intel.
At what point did you receive that picture?
Day or two.
Okay, you mean after visiting the scene, after March 12th?
Yeah, because they got extracted video, then they got.
Maybe the 14th, 15th, something like that?
Yeah.
Okay. And did you include that picture in your report?
In my report?
Yes.
I don't recall, I have to look to see.
Okay.
I didn't put the picture in my report. I'll put the, how I got the information.
Correct.
Yeah.
Okay. So, did you upload that picture to evidence.com?
Yes, everything was uploaded.
And did the person who, I do have a report from Aver, the video extraction log. Was there any sort of report or anything written about pulling these still photos by the person who did it or by anybody else that you know of?
If he did, they do everything. They do everything. Whoever pulls the video, or do all the stills. And
Do you know who that was?
should be Amarine. Should be Amarine.
Okay.
Should be what?
Amarine. How you Stacy? Was Amarine? Amarine. How you pronounce his name?
It is. I can have a spelling here. A, M like Mary, E, R, I, N like Nancy, E. And a police officer is his title.
Yes.
I'm going to show Madam Counsel the picture purported to have been shown to Isis Terrell. In just a moment here, okay? May I approach?
Yes, ma'am.
This is defense proposed.
If that's okay with you, officer.
This is defense proposed exhibit 1. Mark, I should have had you mark, I apologize. Do you recognize that picture?
Yes.
And What is that picture from?
Maybe a driver's license or, you got here on it, you got here on the scale. Probably a previous arrest or driver's license.
Okay, did you show that picture to Isis Terrell?
Yes.
Did you show that picture to Isis Terrell for identification?
Yes.
Okay, and when you were questioning Isis Terrell, how did you ask her to identify him? And there is information on there if you'd like to refresh your memory reading that.
I asked who is this person? She stated the name, and then how do you know this person?
Okay, so that is a picture from, it looks like a driver's license, correct?
Driver's license.
And not from the video, correct?
It's not the video picture. It's not the video picture.
Thank you. I'm gonna come retrieve that. Defense moves for admission of their proposed exhibit 1.
Any objection?
No objection, Your Honor.
Will be admitted as defense 1.
Thank you. When did Isis Terrell call the station?
I don't recall. Let me see.
Okay.
Is it?
I don't mind you for future, I don't mind you referring to refresh your memory when you need.
Okay. Let me see. I know some weeks has passed. March 28th.
And March 12th was the incident date?
Yes.
Thank you. Do you know when the video was uploaded to the social media?
I'll probably say a week and a half later, because it was behind, so about a week and a half later.
Did you ask Ms. Terrell about her relationship with Mr. Davis?
No, I did not.
Did you ask Ms. Terrell about any legal, what's the right word, situations involving herself, Mr. Davis, and their child?
I didn't ask.
You did or did not?
I did not ask.
Thank you.
Did you have any extraneous conversation with Ms. Terrell other than what you've stated here today?
No, just general conversation.
Like small talk?
Like small talk, no.
Okay, nothing material or relevant to this investigation, nothing else?
No.
Thank you. And were you the one that spoke with Casey Hudgens, Ramona Hudgens' mother?
Yes.
Okay, so do you know when Casey Hudgens called you?
Let me refer my notes.
Certainly.
The March 25th.
March 25th.
Yes.
Okay, and Ramona Hudgens, if I understood your testimony right, walked in willingly with or without her mother?
With her mother.
The same day or a couple days later?
Her mother was her ride and her support.
Do you recall if that was the same day?
It wasn't the same day, it was maybe a day or two after.
Okay, and what did you do when they got to the station? I mean, was the setup ahead of time or did they just walk out?
She said she'd give me like a window range because she had to go find her, pick her up, and she'll bring her to the station. So
Casey had to find and pick up Ramona? Yeah. Okay.
Yes.
Okay, so when they came in the station, what happened, such as, for instance, did you meet her? Were there other officers that met them? Did you take them anywhere?
Once I was notified he was here, I took him to another interview room.
Was anyone else with you?
No, just her and her mother, and just me by myself.
Do you recall which interview room?
At the 10th precinct, we only got one, just behind the desk. It's not that big.
Do they have any video in that room?
No video in that room.
Were you wearing a body camera or anything?
I believe I was. I can't recall. I really don't recall.
And was there like a tape recorder or?
No.
Okay. Did you read her rights?
I didn't interrogate her. I just saw her in regular interview statement.
So she has a statement. Was that did she write that out or did you write that out?
I wrote it out.
And then she signed it.
She read it and she signed it.
Okay. I'm just thinking for a moment. Please bear with me.
It's fine. It's fine.
you ask, Ms. Terrell if she would have any motive to identify Mr. Dates?
Not actually.
And I don't recall, I might have asked you this. Were you the one that spoke with Ms. Terrell on the phone, or was that somebody else?
Lieutenant McCord, she took the call first, and then she called me.
Did Lieutenant McCord write anything down from that conversation?
Just her basic information, name, date of birth,
And
contact number.
would you still have that?
No, because it's just like a piece of paper, like a scrap piece of paper.
And are those calls recorded?
Well, the city phone's supposed to be recorded.
Do you have a copy of the picture pulled from the video of Ms. Hudgens and the shooter?
Do I have a copy of it?
Yes. Did you bring a copy with you today?
No, I didn't bring one.
Do you know of anybody that might have a copy that might be available, or another officer in the courthouse from the 10th precinct that was investigating this case?
No.
Did you write down, now, on the photo that I showed you, Defense Exhibit 1, there's actually some statements written that purport to identify Mr. Dates from that picture, right?
Say it again.
Yeah, it's a little confusing. I'll try to be clearer. That picture with the license, is a license photo, we'll assume, okay? With, that has Ms. Terrell's writing purporting to identify that picture as Mr. Dates, correct?
Correct.
This other picture you're talking about that you don't have, that defense doesn't have, that's not here, would that have had any writing on it identifying Mr. Dates?
No, it's on the videos. It's just still pictures, just still pictures from the store camera videos.
And you didn't have her, like, write anything on it, or swear anything on it, or make any statement of evidentiary value on it?
No.
Okay. Mr. Smith said that when you spoke with him, the complainant in this case, he said he didn't know or didn't recognize, couldn't identify who shot him. Is that right?
Correct.
Thank you. Nothing further.
Any redirect?
Briefly, Your Honor. Sir, did I play all the video that was uploaded? Or, I'm sorry, not that specific one, but all the video?
No.
Okay. So I specifically had a particular video that I showed you. That doesn't mean that it wasn't provided. It just, that's
Correct.
the one I showed.
Yeah, correct.
Okay. And additionally, sir, when it comes to Ms. Terrell, who contacted who?
Ms. Terrell contacted the Detroit 10th precinct
And why did she contact the 10th precinct?
to help identify that person in that still picture at the pumps.
Okay, so she knew who that person was?
Correct.
And she came in and clearly identified?
She called and we,
Objection to, I guess, confusion of form, clearly identified as leading.
I will rephrase. She came in and identified.
I went to her.
You went to her, you met her?
Yes.
Okay. And she identified?
Correct.
All right, and sir, would you be aware if stills from the videos were uploaded or not uploaded?
It should have been all over the disc. They all come together.
Okay, so if I told you that all that was received was the videos themselves, would you be responsible for that or no?
No.
Okay. Do you know who was doing the uploading?
I uploaded the videos.com, evidence.com, but
Right.
as far as like the zip file, so what it goes.
Wait, say again?
I said I upload the videos in the zip file to evidence.com. So I'm not here to say, but sometimes stuff don't always go, but it shows 100% complete with the computer. So I'm assuming everything that was on that green light video got uploaded to evidence.com.
And at this time, I would like to share with the court that there was 2 green light videos from the scene. I can share that with I can play it if you'd like at this time, the other video that it was being referenced. I just don't want to be any unclear.
I would
Information about
object
discovery.
depending on whether or not this is a video I've already viewed. So
Right,
I'm gonna have to
absolutely,
slowly
that's.
look at
One at
this.
a time. Okay, sorry. That's what I'm trying to establish, that she has everything I had, Your Honor. I want to make that very clear.
So I'll review,
Okay.
just to make certain this is something I've seen.
What, before you review it, I think you started off by saying, if I want you to play it, it's not for me to, you tell me, present what you feel is.
At this time, Your Honor, it wasn't going to be part of my case. I just want to make it very clear because of things previous, that there's, and make that very clear to the record that video, everything I have has been provided.
Okay, so I don't know that you need to view it because I'm not asking to see it. I'm here to listen to whatever proofs you're going to provide, but it's not for me to determine what is going to be shared. So I don't want us to waste valuable court time if the review was for you to play it.
No further questions, Your Honor.
Okay, any follow-up?
No, but I would like to mark and submit.
Mark and submit, I think, I thought you had, okay, so I've already admitted it as, the photo as Defense Exhibit 1, is that the photo
Yes.
you're referring to?
Yes.
Sure, you can have it marked.
Thank you.
Did you want to publish it to the court?
Yes, please.
You can hand it to Mr. Clerk.
No further questions from me, Your Honor.
Okay, thank you. Thank you so much. You can step down. Any further witnesses for the prosecution?
Not for the people, Your Honor.
Madam Defense?
None for us, thank you.
It's time people would ask for a blind vote for an all
Response?
I object. I object, there is no valid identification in this case, not even enough presented for the lower standard of exam. The only two witnesses that have been called that could potentially identify Mr. Dates because they were actually present at the scene, one of them definitively stated the one that was Ms. Hudgens that was riding with the shooter that evening, definitively stated it was not Mr. Dates. It was an in-court non-identification that was live and on scene without her ever having seen a picture of Mr. Dates, even though it is purported in this investigation that she had previously identified him. She was never even shown a picture of him prior to coming to court. Mr. Andre Smith stated both in the investigation to police that he didn't know who shot him, he didn't recognize him. Whether or not that's credible isn't our question. Our question is it likely, is there a probable cause that Mr. Dates is the person that committed this heinous crime that carries a very severe penalty? They did not, sorry, I'm skipping ahead. So there is only one person left that did not testify that could potentially, or that's what's alleged, identify Mr. Dates. That's Ms. Isis Terrell. It has been stated definitively that she will not be called as a witness. I have gone ahead and I believe the evidence has shown the court that Ms. Terrell, the only evidence that we have that is presented to the court, other than the word of an officer who states there were pictures that both defense and prosecution are missing, or stills of a green light video. The only picture that was shown to Ms. Terrell was not from that shooting. It was not from that day. The picture used to identify the father of her child, who she's had a very intimate relationship with, as both lovers and enemies, and knows very well, was a driver's license picture. And the extent of what is written down and purported to be her statement is this picture LaVon Dates? And who is he? He's the father of my child. That is not evidence of allegation that he was the shooter in this crime. And defense would argue that if the prosecutor is not willing to call her, and if she's not willing to come to court on her own and
and testify to those facts, then it's not a real identification. It's the identification of a driver's license picture, not the shooter in this crime. There's also counts of felony firearm here. And the thing is, you can't charge felony firearm without a weapon. There was one case that I read, a federal case, and I believe there was the Court of Appeals case came later that I'm going to speak about, that said that if there's no weapon recovered and an officer sees the weapon in a person's hand or somebody with credibility can testify, and there's a picture and a video where it can be identified by other people as to the make and model, then that can satisfy the definition of a firearm under the law. But without recovery of an actual firearm, I think it's People v. Henry, because you can't actually call it a firearm. It has to be sent over to forensics, to the Michigan State Crime Lab. And we know that under the legal definition, even inoperable guns are considered working firearms for legal purposes, for the purposes of the criminal justice system. But without recovery of a gun, it cannot meet the legal definition of firearm required for both felony firearm parts. I believe nobody else saw Mr. Dates at the scene of the crime. So we would move to dismiss this case as it is defense's position that there is no legitimate identification. Thank you.
Madam Prosecutor. Thank you, Your Honor. Your Honor, it's not that the people would not like to call Isis Terrell. Subpoenas were sent for every hearing thus far. She did show for the first 3 or 4, but she has stopped coming. She has stopped responding to the subpoenas. The people would ask that we would love to have her be here, but she has not responded to the subpoenas. As to the identifications, she identified we've heard the testimony of Detective Carthan. She called because of video she had seen. She made herself available to the police, not the other way around. They didn't go hunting her down. As to the weapon, because there's a shot fired in the video, which has been provided as evidence.
Wait a second. Are you done responding to the argument regarding identification? Was that it?
No, let me keep going to that. So as to the identification, she came in, she is familiar with him, they have a child in common.
She meaning Isis, who's not here.
Isis Terrell, I'm sorry, yes.
Who's not here.
That is true, Your Honor. And as I said, it's not that she wasn't subpoenaed to be here. She was subpoenaed to be here. The people would love to hear her testimony. And if we want to do yet another in part, we can actually try and do another witness detainer. But she was here for several of, I believe that the court logs will actually show that she was here for several of the earlier hearings earlier on. But she lost patience with the system as it is and just hasn't shown up since. But she did try and make herself available for these proceedings for the first 3 or 4 hearings, Your Honor. Additionally, as to the gun, we see in the video that has been admitted into evidence, there was a gun fired. We see per the testimony of the complainant, Andre Smith, there was a gunshot wound that he received. These are testimony to the evidence that the felony firearm charges can stand. The people would ask that there would be the rest would be a question for the trier of fact, Your Honor, and the people would ask for a bind over on all 4 counts.
Thank you. Okay, so having taken copious notes as this matter has been stretched out over some time, I've reviewed my notes and I've taken into consideration the testimony that was presented today by the prosecution by way of Detective Carthan. Am I pronouncing your name correctly? The concern is, first and foremost, lack of identification. It is not an issue of whether or not the individual that may be able to provide an ID, whether or not they were subpoenaed or whether or not they had been here previously. That's not the issue. The issue is at the conclusion of the prosecutor arresting, is there an identification that rises to the level of what's required at a probable cause hearing. Notwithstanding Detective Carthane's testimony here today, we do not have anything on the record, either today or at previous hearings, with regards to identification that rises, I should say, that rises to the level of a probable cause hearing. And so with that being said, counts 1, 2, 3, and 4 are dismissed without prejudice.
Thank you, Your Honor.
God is canceled. In a minute.
I'm not sure if that was a question, but yes, because the matter's dismissed, that there is no longer a bond. Was that a question for me or a statement? I wasn't
For
sure.
the record, I know my client didn't understand. I know
Oh.
that's his concern, so I just.
For this case,
For this
however, I
case.
believe there are other cases Mr. Dates has.
Yeah, I'll explain it when I go down. Sorry, that wasn't, I know this court understands that.
Okay.
And everybody here.
Okay, Mr. Clerk, I'll hand this up to you so you can add whatever info. Oh, can I trouble you to give that exhibit back to Madam Defense as well? And I don't need signatures on that order. That was my dismissal, but they need copies of it.
Okay.